then as such, this matter may be closed by directing the respondent number 3 to deposit the said amount before the tribunal,
Lordship, High Court.
before the High Court, before the registry of this court,
PCR is adopted.
before the registry of this court, within a period of 6 weeks. 6 weeks. Why 6 weeks? 4 weeks.
Lordship, during the pendency of this appeal, Lordship, this appellant number 1 run over have expired.
Expired. You obtain next to kin certificate.
Lordship, this is I have it with me.
You file an application before the registry.
Oh, Lordship.
In item number 17, or what is the amount?
5 lakhs, Lordship.
5 lakhs.
Additional 5 lakhs.
So in item number 17 also, both of you are there.
Deeply applied, Lordship.
Item 18.
Well, here in this case, kindly peruse the order dated 25/2/2026.
Was on material. After some time.
Much.
Item 18.
None appears for the appellant on top. List the matter after a week. In the event of subsequent non-representation of the appellant, the appropriate order shall follow.
Item 20.
May it please, Your Lordship.
Hmm.
Lordship, as per office note dated 1/6/26, respondent number 1 and 2 has filed wakalat nama. Respondent number 3 is minor. And respondent
number 3.
3 is minor, Lordship.
I know.
Respondent number 4 can be struck off, Lordship. We have filed this appeal on the ground of contempt.
Ms. M. Soikia, learned counsel for the appellant, and Mr.
N. Burua.
N. Borua, learned counsel for the respondent number.
On my lord.
Respondent,
1.3, my lord.
respondent number 123. Ms. Soikia submits that the name of respondent number 4 may be struck off from the array of this appeal. Accordingly, taking note of the submission of Ms. Soikia, learned counsel for the appellant, it is provided that the name of respondent number 4 be struck off from the array of this appeal at the cost and risks of the appellant.
NCR has been received, Lordship.
Ms. Soikia further submits that the LCR has already been received, and as such, the matter may be fixed for hearing. Accordingly, it is provided that SSL list the matter for hearing after 4 weeks.
Obliged, Lordship.
Item 21.
May I please. That this high is, my lord, for condonation of delay of 210 days, my lord.
45
210 days, my
or
lord.
210 days. Okay.
And filing RFA, my lord. Grounds, my lord, I have stated in paragraph number 4, 5, 6, 7, and 8.
Mr. Imtiaz, do you have filed objection here?
No, my lord, we seek some further time.
Lord.
Objection, my lord.
Pardon?
Some time may be granted, my lord.
My lord, problem is that, my lord, execution proceedings, my lord, going on. In view of the, my lord, order of the Honorable Supreme Court, my lord, the execution, my lord, is
My lord, the execution case is fixed on 3/7, my lord. My lord, and date may be fixed before that. Or my lord, it may be fixed on the next week, my lord. Basically, we have failed.
Okay. Heard Mr. Soikia, sorry, R. Sharma, learned counsel for the applicant, and Mr. MTS for the respondent. Mr. MTS submits that he may be granted some time to file objection. Fair allowed, SSL list the matter on next Wednesday.
On 10th June.
oblige me.
Then 22.
None appears for the appellant on call. However, Mr. Loskar, learned counsel for the respondent present. Lays the matter after a week in the event of subsequent non-representation of the appellant, appropriate orders shall follow.
Date to be fixed, kindly.
115 June. Item 23.
May I please your lordship kindly prosecute the matter for time being?
Okay.
Please, lordship, I am sorry, lordship, I am on the in court, another court, lordship. Item number 7, lordship, I am the appellant.
Item 24. Yeah, please. Service report respondent on 2 and 3 yet to be received, my lord.
Hmm.
The matter may be, my lord, posted for mediation, my lord.
Mediation. Mr. Colita?
But it can be sent for mediation. Since the appeal is for quantum, my lord.
Only quantum, my lord.
Okay. We may refer the matter to the mediation. Okay. Oh, who is a respondent number?
2 and 3 owner and driver, my lord.
Owner and driver.
What is the insurance company?
Okay. So their name may be struck off also from
Maybe,
the
my lord.
awareness.
For my submission was my lord, they should remain, at least the owner should remain because we are going to indemnify the owner only. So he should be, he's a necessary party in my understanding, my lord.
No,
We are
if
going to indemnify him
if
only.
the insurance certificate was valid at the time of accident, then
It was what just an accident.
it was valid.
Yes, my
Then
lord.
My lord,
An appeal is only, my lord, quantum, my lord.
if we are in the proceeding, my lord, because we are in the role of an indemnifier, my lord. If the
no,
indemnifier-
Mr. Kolita, you say, he is the appellant. It is his prerogative, whom he will implead or whom he will not implead, or against whom he will proceed or against whom he will not proceed.
That is the discretion of the claimant, of course, my lord. But the relation between the insurance company and the owner, my lord, he is being an insured, my lord, of our policy.
Okay, then let it be referred to the mediation.
My lord.
Heard Mr. Borua, learned counsel for the appellant, and Mr. Kolita for the respondent. Office note dated 1/6/2026 indicates that neither unserved notice nor AD card in respect of the notice issued to the respondent number 2 and 3 received back by the sex until date. However, Mr. Borua, learned counsel for the appellant, submits that this appeal is preferred only for enhancement of the quantum of compensation, and as such, the matter may be referred to the mediation. Mr. Kolita, learned counsel for the respondent number 1, also submits that the matter may be referred to the mediation. Accordingly, taking note of the submission of learned counsel for both the parties, this matter is then referred to the Gauhati High Court Mediation Center, and both the parties are directed to appear before the mediator on or before
Before vacation, date, my lord.
before vacation, 15 June. Okay.
Hello,
After the mediation, the mediators will file a report before this court.
Item numbers 25 and 26.
May I prefer? In preferring the appeal, there was some delay, so I filed an interlocutory application for condonation of delay. Now, while issuing notice, after issuance of notice, we came to know that respondent number 2 has expired. So for that, we have filed 3 applications, one for delay condonation, one for setting aside abatement, and for substitution of legal heirs. And in the delay condonation 1423 of 2024, notice was issued. We have taken steps. Lordship may kindly peruse office note dated 1/6/2026. Service upon respond number 2, 1 to 25 is complete. And respond number 3 address is left. So for the purpose of this delay condonation, along with setting aside abatement and substitution, their presence may not be required at this moment. Lordship may kindly consider my application 1423, 1422, and 1424 may be allowed.
Yes, Mr. Asarji,
Lordship.
any objection? No, Lordship. No objection.
Lordship, but only one point is section number 2 has died on 31/7/2010.
Hmm.
The penalty is given there. The exponent 2 has died on 31/7/2010. And judgment was delivered on 2017. So during, at the time of the delivery of the judgment, 2 was already expired. Whether the judgment is, and he's the owner. The judgment is basically against the owner. We only need it by. That's it.
My lord, it is judgment, my lord. In paragraph 3, it is written that the case proceeded ex parte against 1 and 2. So the tribunal was not aware that this person has died long back.
Hmm. Okay. Heard Mr. Bhattacharya, learned counsel for the applicant, then Mr. Asarji for opposite party number
1.
1. Referring to office note dated 1/6/2026, Mr. Bhattacharya submits that notice upon respondent number 2, 1, 2, 2, and 2, 3. Two, 4, and 2, 5 stands served. And the said office note also indicates that notice issued to the respondent number 3 could not be served. As he could not be found out in the address furnished, and nobody knows about his name. Mr. Bhattacharya submits that for the purpose of this application, the presence of respondent number 3 may not be required. And as such, he has contended to allow this application, which is filed under Section 5 of the Limitation Act for condonation of delay of 4,874 days in filing the application for setting aside abatement. In respect of respondent number 2, Mr. Bhattacharya submits that respondent number 2 suffered demise when
31/7/2020. 2010.
31/7/2010.
2010.
2010.
Paragraph 3 I have stated.
But the legal heirs of the said respondent could not be impleaded, and the reason has been explained in paragraph number 3 of the application. Then under such circumstances, Mr. Bhattacharya submits that the delay in filing the application for setting aside abatement may be allowed. Mr. Asarji, learned counsel for the respondent number 1 submits that respondent opposite party number 1 submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this application stands allowed. Delay of 4,874 days in filing the application for setting aside abatement. And also the delay of 4,934 days in substituting the legal heirs of the deceased respondent number 2, namely Mr. Dinobandhu Nath, extends condoned. In view of the order passing this interlocutory application, the applicant shall file amended post title within a period of
Within a period of 1 week, madam.
1 week from today. 1 week from today. In view of the order passing this IA number 1423, the IA number 1424 and IA number
1422.
IA number 394 of 2023 stands closed.
My lord,
We have to submit the
394,
matter after a week.
no, 394 is pending, my lord. That is the original delay condition petition. There I have to
Okay.
amend the cost
Alright.
title.
Not 394, 1422.
1422.
Mr. Bhattacharya, learned counsel for the applicant shall file amended cost title in IA civil number 394
Yes.
of 2020 within a period of 1 week from today. Next item.
Apply.
Pending item 18.
Well, kindly just peruse the order dated 25/2/2026.
Yes, Mr. Katonia, what is the position?
Well, I have received an instruction, madam. The legal amount has already been credited to petitioner's account, madam.
Entire amount.
Yes, madam.
Well, not the entire amount, the amount which have the sanction earlier, madam.
Hmm.
I have already pointed out, madam. Not the full payment has been made, madam. Not fully complied with the order, madam.
Hmm.
That amount has been received by the petitioner.
Hmm.
But in that respect, my lord, your lordship has already been directed. If there is something, then they have to file an affidavit to that effect. Why the petitioner have not been given the full payment which
Hmm.
is directed by this honorable
Payment has been made according to the number of working days, madam, because they are not working regularly.
But that was not raised in the writ petition, madam. The direction of this honorable court is very clear. The payment has to be made from the 2007 to till date at that point of time, madam. So now, in the contempt proceeding, my lord, in the contempt proceeding, the judgment and order of this honorable court has to be complied with without any reservation. That is a catina of judgment of the Supreme Court. At this stage, they cannot say they have not working at that point of time. Because in the writ proceeding, and neither they have filed any appeal, nor they have filed any review petition. Now in the contempt proceeding, they cannot raise such type of questions. So my humble submission, let them file the affidavit as to why they have said that the petitioner has not been working or whatever may be. Well, they have to file the affidavit to that effect.
Mr. Katonia, you have not filed any appeal against the judgment passed by this
No,
court
we have not.
in the writ petition.
Direction was to verify whether they are in service or not, my lord, and to make the payment, my lord. So accordingly, we have
Direction for.
verified and we found that some of the petitioners are regularly working. One petitioner is regularly working, is getting salary. But others are, my lord, they are not working regularly. According to the number of working days, we have made the payment, my lord.
Well, just the peruse the direction, my lord. In the contempt proceeding, page 16, last paragraph, in the instant case, petitioner were appointed in the year 1989. They have rendered service for more than 28 years now. As a matter of fact, they were paid salary up to July 2007. That is for a period of 18 years. Continuance in service by the petitioner is not disputed. And As per the admitted stand of the respondents, no termination order has been issued to the petitioner. In such circumstances, withholding of salary of the petitioner would not be justified. Consequently, impugned order dated so and so is set aside and quashed. Respondents are directed to release the arrear salary of the petitioner from August 2007 within a period of 4 months from the date of receipt of the certified copy of this order. Current salary for the month of February 2017 shall be released within a period of 3 months from the date of receipt of the certified copy. Retribution allowed, but without any order as to cause. There is no such observation to verify or examine.
If they are not working, they will not.
Nothing.
That is simple.
That is they have to have been filed a review petition or the appeal.
It will not be filed.
If their stand is very clear, there is the admitted stand. They have filed an affidavit. In the affidavit, clearly said the petitioner were working, and that has been reflected in the order itself. That is the admitted position. So now in the contempt proceeding, they cannot say like that. So my humble submission, let them file the affidavit then.
Mr. Khatuniar, there is no such order for verification.
No, but while we're making payment, we have to see whether they are working or not. But now we have verified it.
No, whether you have taken such a stand before the read court.
Because in the report, whether they are working or not, that issue was not there.
Then can you no, having not raised such an issue before the read court, can you raise the issue before
Yes,
the
my lord.
contempt court?
While we are complying with the direction of the read court, my lord, then we found that they are not regularly working.
Hmm.
Since there was a direction to make the payment, so we have made the payment according to their attendance, my lord.
Okay, you file an affidavit.
Yes,
then.
my lord.
There is
Uh,
a clear but continuous in service by the petitioner is not disputed and as per the admitted stand of the respondent. That has been reflected in the order
Petition
itself.
was not disputed when the petition was heard, my lord. Thereafter, they are not working.
hmm.
Because if we go through the same, my lord, they have not given 2007 to 2014. Some of the petitioner, they have released the payment
Okay,
2014 to 2016.
Heard Mr. Islam, learned counsel for the contemners, no, for the applicants, and Mr. Khatuniar for the contemners. Mr. Khatuniar, during the course of hearing, has produced one letter of the Director of Secondary Education addressed to the Standing Council,
elementary, ma'am.
Gauhati High Court. Elementary Education addressed to the Standing Council of the Gauhati High Court, dated 20th March 2026, and on the basis of the said letter, he submits that the amount of arrear salary has been credited in the account of the applicants. However, Mr. Islam, referring to the order of this court dated 25th of February 2026, submits that the order of this court dated 17 to 2017, passed in WPC number 3286 of 2014, has not been fully complied with. In that view of the matter, no, however, Mr. Khatuniar, learned counsel for the contemner, submits that the entire amount could not be paid, as during the course of verification, it has been found that the applicants herein were not working in some of the days, for which the amount could not be credited. Entire amount could not be credited in their account. But perusal of the order of this court dated 17 to 2017 in WPC number 3286 of 2014 indicates that no such direction was issued to the contemners respondents for verification of the working days of the applicant writ petitioners. However, taking note of the submission of learned counsel for both the parties, it is provided that Mr. Khatuniar, learned counsel for the contemner, shall file a short affidavit indicating therein as to why the entire amount of the arrear salary could not be deposited in the account of the applicants within a period of 1 week from today. Registrar shall list the matter on 9th of June.
No, but
12 15th of June.
15, okay.
March April.
For third matter, then it is a 12,
Yes, madam.
12,
Well, 12, I have some personal difficulties. I will not be able
12,
to.
then 11.
Well, after that one, 10, 11, 12, I will not.
Then
be-
after,
Fifth.
then after vacation,
Yes.
after vacation on 13th,
Yes.
15 July.
Obliged.
My lord, this matter may kindly be taken after a few minutes because I could not verify the record. Actually, due to one of it mistake of someone, the case was shown as disposed of. And thereafter, it has been restored. So let me verify the record after 5 minutes.
May I please, Doctor? May the matter of time being highlighted, snail of this. Hearing corresponding to 5 6.
Okay. After some time.
Lordship, as per official dated 22/5/26, service is complete, Lordship. Yeah, delay petition of 55 days. Lordship.
Heard Mr. Soikia, learned counsel for the applicant. Referring to office note dated 22nd of May 2026, Mr. Soikia submits that a notice upon respondent number 2 and 3. 2 and 3 has been served. But no one entered appearance on behalf of respondent number 2 and 3. List the matter on next Monday.
Public.
Disseminate regarding success certificate case, Milord, in this case. Now, I applied for the success certificate, Milord, but my case has been rejected. I am in the first wife and the respondent one, Milord. Children have got, Milord, but the respondent one is the second wife. So that is the my full case, Milord. And the deceased, Milord, was serving in a government post, Milord, and died, Milord, in 2019. So your lordship was pleased to admit the same matter, Milord, on 25/7/2025. So respondent has appeared, Milord.
So service completed, yeah,
Completed.
completed.
They have appeared.
LCR has been received.
No.
LCR has been received.
LCR has come.
So we'll fix the matter for hearing then.
But any date short date, Milord, so is pending for pension matter, so.
Maybe.
Any date, Milord.
Heard Mr. Proceed, learned counsel for the appellant, Mr. Ali for respondent number.
Sorry, Doctor. My thing was 33. Sorry.
Okay. Ms. Bora for respondent number,
I have all the respondents. And
all the respondents.
to them, it being 40%.
Okay. It appears that service in this matter has been completed
Hearing it.
Immediately after the.
and the TCR has been received. And as such, this will fix the matter for hearing after 2 weeks,
Immediately after the.
immediately after vacation.
Milord. In the
Immediately
individual lordship,
after
Milord, then it
reopening of
can
the
Milord, on the July, Milord. 13, 14 July or Milord, 20 July.
You take a date from him.
My lord.
May I please be lordship? According to office note dated 35/26, AD cards of respondent number 2 and 3 is awaited lordship. The
LCR is received. And so the registry may kindly be directed to place the postal tracking, and respondent number 1 is responded by Wakalatnama.
Art Mr. Agarwal, learned counsel for the appellant, and Ms. L. Sharma for the respondent number 1.
Yes.
Office note dated 38/5/2026 indicates that neither ID card nor answer notice in respect of respondent number 2 and 3 has been received by the registry till date. List the matter after 2 weeks, and in the meantime, registry shall track the consignment in the website of the postal department and put up an up-to-date office note. Registry shall list the matter after 2 weeks. Ms. Sharma submits that she has not been furnished with a copy of the memo of appeal.
Received.
Mr. Sharma, no, Mr. Agarwal, learned counsel for the appellant shall furnish a copy of the memo of appeal to Ms. Sharma during the course of the day. Mr. Agarwal, you file. You
It is submitted. It is
during the course of the day.
okay. 32.
So, Doctor, you are for respondent. The other side is absent. None appears for the applicant on call. However, Mr. N.M. Dotto, learned counsel for the opposite party number 1 is present. List the matter after a week. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
33.
Mr. Ali, you are for respondent number 1. Respondent number 1. Service in respect of respondent number 3 and 4 completed?
Your lordship, 3 and 4 not completed.
Not completed.
Three and 4 and 1.
No. As per office note dated 2/4/2026, the notice for the respondent number 3 and 4 have been received.
Your lordship, 3 and 4 has been received, and 2, 4, sorry, your lordship, 2, 5, 6, 7, we have filed the affidavit of service, justice service regarding respondent number 2, 5, 6.
I am asking about 3 and 4.
Yes, they have been received here.
Okay. Any objection of Mr. Ali? Any objection in?
There is a delay of 12 years, 8 years. That order was passed during lifetime of predecessor of the present petitioner in the year 2012.
No,
And
have you
that-
filed any objection here?
Yes, sir. I am-
You have filed.
Their father remained silent for long 10 years. In the meantime, that order attained finality. Now, legal hair, after more than 12 years, 8 months, filed this application without any explanation why their predecessor remained silent for long 10 years.
What is
Lordship,
your
the delay-
explanation?
We have provided the explanation. If your lordship may kindly fix it, I can argue the matter, your lordship, because we have received the objection. I mean, So, and.
Today you are not ready.
Not ready, Your Lordship.
Pardon, sir, your name, please?
GR Datta.
GR
Datta.
Dotto,
Yes.
learned counsel for the applicant, Mr. Ali for the respondent number 1. Office note dated 1/6/2026 indicates that after effecting service upon respondent number 2, 5, 6, and 7 by Dusty Note, an affidavit has been filed by the applicant. And the perusal of the affidavit filed by the applicant indicates that notice upon respondent number 2, 5, 6, and 7 deemed to have been served. And as per office note dated 2/6/2026, service upon respondent number 3 and 4 also appears to be completed. The learned counsel for the applicant, however, submits that he has received the objection filed by the respondent number 1, respondent opposite party number 1, and he pressed for listing the matter after a week.
Yes, Your Lordship.
After a week, so as to enable him to go through the
But
affidavit
any
filed-
date, may be-
objection filed by the respondent number 1.
if any date may be fixed, Your Lordship, any date.
Correct.
15 July, sorry, 15 June.
This is at least the matter on 15th of June.
Deeply.
May I please be Lord? Sorry for interruption, Lordship. Lordship, item number 31, Lordship. I have already supplied the copy and acceptance notice also I will file.
You inform the council.
After,
Standing items, item number 23.
Record come, but in original proceeding also they are not appear. Whatever first expertise. Now also there is no response.
Is it an ex parte order?
Expect order. So next week, fixed for admission of the. There is not response.
As per office note,
Office note,
service report has not been received.
yes. So expected hearing will be admission hearing or it may be disposed of.
No.
Record
Notice
come.
has to be served. You served the notice by Dustin Mood.
Just to do whatever, hand to hand. Okay, not possible, madam.
Why?
There is some problem is there.
Problem is there. Then
Puppet
you take
puppet
a-
was also possible, it was expected.
You take a step by this speed post and also by usual process.
Yes, madam.
Heard Mr. J. Ahmed, learned counsel for the appellant. Office note dated 25th of May 2026 indicates that neither ready card nor unserved notice in respect of the sole respondent has been received by the section filled. Accordingly, it is provided that of Mr. Ahmed, learned counsel for the appellant shall take fresh step upon the sole respondent by speed post and also by usual process which in you from today. This is at least the matter after 4 weeks. Okay.
It may be 3 weeks. I will also 2 weeks. I will also permitted to take a time, my lord, justice.
Okay, after 3 weeks. Mr. Ahmed, learned counsel for the appellant further submits that he may be allowed to effect service upon the sole respondent by Dusty They are allowed after effecting service by Dusty an affidavit to that effect shall be filed before this court.
After 2 weeks, my lord.
4 weeks. Timing 27.
No, not for 3 weeks.
May I please, Lords? My lord, in this case, due to some perhaps misunderstanding, I filed a substitution petition. But the learned court disposed of the matter on 17/5/24. The main testamentary appeal was disposed of on withdrawal. Actually, that was not my prayer. Then when I brought the matter to the notice of the Honorable Court, that was restored on 29/5/24. Passed in TA number 3, 2017. 29/5/24. So I was on good faith. In the meanwhile, the original petitioner died. His legal heirs are sought to be brought on record. But the Honorable High Court, by order dated 17/5/24, this was disposed of. That means substitution was not allowed, because at that time the main suit was dismissed, found as dismissed on withdrawal. It was restored only on 29/5/24, and this substitution petition was not allowed on 17/5/24. So at that time, the title testamentary appeal was on dismissal order. So now case has been restored by order dated 29/5/24. Now the substitution petition should be taken up for disposal.
What is the number of that substitution application?
Yes, but just some at the communication gap losses. May I request lordship to go through 1591/24 lordship.
Yes.
In that order, due to some mistake, the entire testamentary appeal was disposed of. As there is no provision for substitution of executors in the testamentary appeal, lordship, legal heirs of executors. Last line, last paragraph of that order, lordship, clears that only 930 has been disposed on withdrawal now. So 930 is no longer alive, lordship. 930 has already been dismissed on withdrawal. Testamentary appeal has been revived, and thereafter they have filed this present petition, lordship, 1680 under 258. That is under 258 lordship, and that is not maintainable also.
That may be heard later on, but today the matter is this: after dismissal of the order, after registration of the testamentary appeal, this matter may be taken for substitution as well as administrative petition may be taken up for hearing. We will argue on that point.
Which application?
My lord?
Which application?
My lord?
Which application?
Application that is 1680,
number?
1680 and 930.
930 is a disposal.
No, 930, that may be treated as non-east in the eye of law, because at that time testamentary appeal was dismissed because of wrong presumptions. It was dismissed on 17/5/24, but it is restored on 29/5/24. So thereafter it was not dismissed. It was dismissed earlier. But when the testamentary appeal came into force, now matter should be taken afresh.
This I
Clear,
number 930.
yes. And two petitions are there. Whether it is maintainable or not, that lordship may hear the matter in another date. But today, lordship would see that the restoration was 29/5/24. All the orders which my learned friend is referring, that was earlier order. But when the suit, the testamentary suit has been restored, everything will come into force, my lord. Now, whether new petition has to be filed or not, that is another matter. So on that point, what my learned friend is saying.
May I read the order, lordship, of 1591?
Okay, not necessarily we will hear on the maintainability of this application under section 258.
Yes.
Yes,
You have
may I
received
read
the copy?
order, Lordship? What my learned senior counsel has missed there, Lordship. The learned counsel for the applicant, it is under 29(5) on 1591, Lordship. The learned counsel for the applicant further submits that the order passed in ISC 9.
No, Mr. Uddar,
Lordship,
we will issue notice in this IN number 1680.
Lordship.
If you have any objection, you file objection.
No, objection is not required, Lordship. Otherwise, my verbal submissions may be recorded, Lordship. But
Okay,
definitely
he
will
prays
objection.
for fixing the matter on some other date.
Lordship.
Let it be on some other date.
For hearing both the matters, 930 and 1680.
Okay.
9(3) is no longer existence, Lordship. I just allow me to
My
read the
learned
order.
friend,
Just
please,
allow me to read the order.
please,
No order,
please try to understand. That is not an on 17.5 it was there.
Allow me to read the order.
That is restored on 29.5.
It will clear everything,
So
Lordship.
before taking birth the main case, the son was killed. But when the main suit has come, everything will come. So on that point, Lordship may fix a date for hearing. In my humble opinion, my lord, when the main case has been restored, everything has been restored.
Heard Mr. Mahmood, learned counsel for the applicant, and Mr. Poddar for the respondent number, opposite party number
5, 7, 8, 9, 10.
5, 7, 8, 9, 10.
It is correctly showing for others.
And Miss, your name, please? Espal, learned counsel appearing on behalf of respondent number 6. And for other respondents,
Mr. Vijay Mukherjee was there. The other post will be already in expert use. They have not contested the other part also.
this application under section 150 or 258 of the Indian Succession Act is preferred by the applicant. For executing the will property in favor of the deceased and Dulal Chandra De,
Dulal Chandra De.
the appellant of testamentary appeal number 03 of 2017. It is submitted at the bar that all the parties are represented before this court. And as such, Mr. Mahmood, learned counsel for the applicant, submits that this matter may be taken up along with item IA number 930 of 2024 after a week. Accordingly, it is provided that recess unless this application.
Let it be after 2 weeks, my lord.
This full proxy. This is an order.
If respond listing the matter, okay, we'll take a call on that day.
Okay.
We'll
We
take
may-
a call on that day.
As per law, you have also the right to file afresh because main case has been restored. So, my lord, may kindly fix them after 2 weeks, my lord.
Cover after 2 weeks.
Problem.
17 June.
17. Okay.
Item 35.
None appears for the appellant on call, lays the matter after a week. In the event of subsequent non-representation, appropriate order shall follow.
37. Lordship, we have taken steps, Lordship, in the main case, Lordship, on 6/5 and note order office note that we have already sent by regular post as well as regular mode, Lordship.
Heard Mr. Poddar, learned counsel for the appellant. Office note dated 38/5/2026 indicates that this year has been received. However, neither service report nor unserved notice
Estimate
issued in
directed
respect of the respondent.
Tracking report, Lordship. tracking report, postal tracking report, lordship,
has been
service.
received till date by the section. Accordingly, it is provided that registry shall track the consignment and put up on up-to-date office note after 2 weeks.
IA, there is a interim stay order, lordship. That may be continued, lordship.
Or Mr. Putter, learned counsel for the applicant. Office note dated 15/5/2026 indicates that no report has been received in respect of the notice issued to the sole respondent. Accordingly, it is provided that registry shall track the consignment and put up one up-to-date office note. This is the matter after 1 week, no, 2 weeks. In the meantime, the interim order passed earlier shall continue.
Obliged.
38 and 39.
May please your lordship. This review application is filed by the my lord SMDC Amranga Borihat School, my lord, to review the your lordship's order dated 2024, passed in WPC 6/30/2024, my lord. Wherein your lordships, my lord, directed the inspector of schools to release the my lord, then my lord royal and non-royal certificate, and also your lordships directed to hold that 25% of the return and benefit of the petitioner till dispose of the my lord, that my lord, and the dispute regarding my lord payment of the my lord. So my lord, at
Service completed,
my lord,
service completed,
my lord,
service completed.
the service, my lord, notice has not been issued in this matter regarding my lord review application, my lord.
Notice was not issued.
At this the notice may be issued, my lord. My lord, the leave was granted by your lordships, my lord.
Leave was granted.
Yes, ma'am.
Heard Mr. Sharma, learned counsel for the petitioner. Mr. Soikia for respondent number? No, in review petition. Review petition. You are not appearing in review petition. Okay. But you are a party here.
On behalf of the second deputy.
Also heard Ms. Terampi for the respondent number 2. Director Secondary Education.
Yes, sir.
And Director Pension and Public Grievance. Ms. Bowman for the respondent number 3. AG. Miss, your name? Learned counsel for the respondent number 4. And inspector of school? You. 5. For state of Assam then? You can appear, Mr. Soikia, for the respondent number 1.
5.
This review application under order 47, rule 1 of the Code of Civil Procedure. Read with Article 226 of the Constitution of India is preferred by the applicant for review of the order dated 24/9/2024 in WPC number 632 of 2024 passed by this court. Let notice be issued to the respondents returnable in 2 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing counsel. But there's a,
On the 6 and
6 and 7.
You have to register post. Or speed post or register post. But my lord,
No, then not 2 weeks, but 4 weeks,
yes, my lord.
after 4 weeks. Step upon respondent number 6 and 7 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, and 5, since they are represented by their standing counsels. However, extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 4 weeks.
Yes, my lord, I will serve.
In contempt petition, perhaps the petitioner is absent here.
Even while a PP order has issued, madam. PPO has
Issued.
issued.
But they are not pursuing the matter. Applicant is absent here.
It's released on my 5/3/2020.
None appears for the petitioner on call. However, Mr. Soikia, learned standing counsel for the respondent number.
I am for the respondent number 5.
Respondent number 5 present. And Mr. Soikia apprised this court that PPO has been issued to the petitioner of this, to the petitioner. However, list the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
PPO issued on my 5/3/2020.
5/3. Okay. PPO was issued on 5/3/2025.
6, madam.
6.
5/3/2020.
Economical school. 4 weeks or 4 weeks? Total 4 weeks.
It says your lordship, as per office note dated 1/6/26. Unserved notice for respondent number 2 has been received back with postal remark insufficient address. But the usual process may be called. And for 3 lordship, it is served lordship. That is in flag A.
Part Ms. Mozumdar, learned counsel for the appellant. Mr. I hope learned counsel for the respondent number 1. Respondent number 1. Office note dated
1/6/26.
1/6/2026 indicates that unserved notice in respect of respondent number 2 has been received back with the postal remark in inverted comma insufficient address, and postal tracking report of respondent number 3 indicates that notice was delivered to the addressee. And the concerned report has been placed at flag A. And perusal of the same indicates that notice was delivered to the respondent number 3, and as such, notice deemed to have been served on respondent number 3. List the matter after 2 weeks, awaiting service report upon respondent number 2.
And TCR. TCR has not been listed.
The office note dated 1/6/2026 also indicates that LCR has not been received. Justice shall issue urgent reminder to the learned tribunal for transmitting the record.
The I lordship, the I we have filed.
Caveat,
In that
you have filed the caveat. Caveat
I have
will
filed
be
one
heard.
IA lordship. It's 13898.
Caveat would be heard. Caveat stands reserved. I for
I for lordship, this appeal has been admitted without making 50% or awarded amount lordship.
no, whether the judgment was stayed.
No lordship.
No lordship.
State lordship.
Their I lordship, they are challenging the order in the appeal.
No,
The admission, yes, the prayer.
I'm paid for modification of this order lordship. As because lordship in their appeal, the main contention is that that lordship would, this order would be that pay and recovery option, as because there is a violation. There is a invalid DA and there is no permit. So in that regard, lordship, I have filed this IA that suppose it is you that will become that policy violations will be there. Then lordship, obviously it comes lordship pay and recovery options. Lordship is very much aware. This apex court is constantly reiterated this several judgment that victim third party, I am the third party, could not be suffered. Their main contention is that
No, Mr. Hawk, you see, though the appeal was admitted, no stay was granted.
yes,
In that also notice was sent, lordship. That's what I was submitting.
but whatever LCA has been called. So ultimately in my IA lordship, I have already categorically mentioned that the lordship I am LCA already called. So the patient claiming it's not positioned to file execution proceeding. Yes, because LCS already called lordship.
Lordship, they are challenged. They have also annexed the order in the appeal. Appeal was in lordship will peruse page number 8.
No,
Yes.
they, madam, they prayed for modification of that order.
Yes, lordship.
Yes, appeal. It is admission of the appeal, lordship.
Anyway, you file your objection then.
No, lordship, there cannot be any objection because my appeal is admitted by that order. And lordship, in our IA notice, he was present and notice was sent. That's why lordship will take up 794 of 26.
You file your objection in this IA. We'll see.
Can I make oral objection, lordship? I am having
Pardon?
some problem in my chamber right now because of some medical issues, lordship.
Maybe.
Can I make oral objection, lordship? Or I can take 4 weeks time that way.
Okay, all
Because
right.
I can make this, he is challenging the admission of the appeal and modification. Then it has to go to that appropriate bench first of all. And appeal it will be final hearing.
Okay,
lordship.
let it be before the appropriate bench.
Yes, lordship.
Heard Mr. Hawk, learned counsel for the applicant, and also heard Mr. Mojumdar, learned counsel for the respondent, opposite party. This application is preferred by the applicant for modification of the order dated 13/3/2026. Passed in MSC appeal number 111 of 2026. Raises at least the matter before appropriate bench.
And in another the stay petition, IA lordship notices were sent. Registry has not given any office note on postal track report, lordship. Office note is regarding sending the notice.
Okay. Third, Ms. Mazumdar, learned counsel for the applicant, Mr. Hawk for the respondent opposite party number 1. Office note dated 4/5/2026 indicates that notice has been issued to the respondent number 2, but no report has been received till date. Accordingly, it is provided that registry shall track the consignment and put up one up to date office note and list the matter along with MSC appeal number 111 of 2026 after
Kindly given at the lordship.
No, this matter will be listed before the appropriate bench.
Otherwise, lordship, this
Within a period of 2 weeks.
3 weeks, lordship.
3.
I'll be out of station. Highly obliged.
lordship, kindly given at
They debo noire.
otherwise, lordship.
41. May please, your lordship. In this case, last application, your lordship was pleased to direct the insurance company.
Otherwise, my lord, company decide to take this matter in coming Lok Adalat, ma'am.
What is the question of fact? Sending the matter to the local adalat, my lord.
they never want to withdraw their appeal, my lord. After discussion, my lord, they were ready to withdraw their appeal, my lord. Insurance, my they were submitted.
No, regarding this quantum of compensation to be paid,
Madam.
they have given one calculation sheet. What instruction is available with him in respect of this calculation?
They were not ready to pay only interest part, my lord.
How they can now, my lord. My lord, learned the-
There was no order that with interest, they have to withdraw the appeal, my lord. That's why, my lord.
No, what are the terms and condition of the compromise?
No, simply that was withdrawn, my lord. Since the insurance company has withdrawn their appeal, my lord, we have also agreed to withdraw our appeal, my lord. Both the appeals were withdrawn, my lord.
Fault of our company is only, my lord, they have only verbally discussed about the
That
case.
is the abstract question now, then they are raising now,
There
my
is
lord.
no written statement, my lord. That's why, my lord, they want to fix the matter coming over the board, either in mediation, my lord.
That since the matter has already been settled, my lord. They have decided the tribunal, my lord, but
Where is that order, settlement order?
that is the judgment, my lord. That is the judgment, my lord.
Yes.
But no, right.
They only simply withdraw the matter, my lord.
Page 10, my lord, page 10 of the IA, my lord. IA 14681, my lord. Page 14, my lord, the relevant purpose, my lord, of the award, my lord.
So against this order,
My lord.
appeal was preferred.
By the claimant also, as well as the insurance company also, my lord.
Okay.
We have filed our appeal for enhancement of the compensation, my lord. They have filed their appeal against the award passed by the tribunal, my lord.
It's passed by tribunal, my lord, 18 lakh something, my lord.
Thereafter, the matter was referred to the local adalot.
No, my lord. At no point of the matter was referred to the local adalot.
No, my lord.
It was not
Now
referred
they
to
are
the.
paying. They are facing for.
No,
changing
how the
matter.
matter has been settled?
We contest
No.
the appeal, my lord.
Here, both the appeal filed by the claimant as well as by insurance company, both the appeals were withdrawn, my lord. That was not praised. Both the appeals were not praised.
Both the appeals are withdrawn.
Withdrawn, my lord.
Where is that order?
But that order is, my lord.
Only simply
Not simply.
praise the instant appeal, my lord.
That will be, my lord, page 16, my lord.
17.
Or 11 portion is at 17, my lord.
Only simple order is there, my lord.
Page 17, my lord. So learned senior counsel assisted by so and so. The learned counsel appearing on behalf of the appellant submits that the appellant herein would not like to praise the instant appeal, and the same may be closed as withdrawn, my lord. The other appeal, the insurance company, the same order was passed, my lord.
Let the matter be fixed at mediation, my lord. They were discussed and solved the problem, my lord.
What is the question for sending the matter to the mediation center, my lord? The matter has already been finally settled, my lord.
No, Mr. Das, you say it is not indicated in this order
Yes.
how the matter was settled.
Yes, ma'am.
My
It
lord.
is simply withdrawn.
Yes, ma'am.
Simply
Thank
withdrawn,
you,
my
my
lord.
lord.
Now I'm extremely as part of the judgment passed by the motor accident claims tribunal. They have the insurance company is bound to make the payment, my lord.
In
Yes.
every local adalat, my lord, claimant pays the interest part. Then
Where is that order?
not
No.
Where is that order?
In every local adalat, my that's why,
No. Where is that direction to waive the
No direction,
interest?
my lord.
Then
No.
on what basis you are submitting before this court?
And it is not directed by the court
Then
to pay the.
you are bound by the judgment and award passed by the tribunal.
Tribunal, my lord.
You comply with it?
Judgment was passed as far back on 18/6/2010, but 16 years have already passed, my lord.
But after their discussion, my lord, our. appeal
No, no, no,
was
no.
also, withdrawn
This kind of,
by us, my lord.
no, no. Now we have to comply with the order of the tribunal,
My lord.
award of the tribunal. Why should we refer the matter to the mediation again?
My lord, actually, in tribunal, my lord, 18,63,000 only this award is awarded, my lord, to them, my
You
lord.
comply
Now
with the,
we
you
have
comply with
complied, my
the,
lord. After
no,
50
no, 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 no.
already paid 11 lakh.
You,
something, my
you
lord.
comply with the award passed by the tribunal.
Yes, my lord.
Otherwise, we will restore both the appeal and we will hear it. And we will increase the interest
Compensation.
amount from 6% to 9%.
After their discussion, my lord, we have
No,
withdrawn
no,
our appeal,
no,
my lord.
no. You comply with the judgment and award of the tribunal.
But we have also, my lord, filed our appeal, my lord.
We will
That has
restore
also-
both the appeal then.
But that has also been withdrawn, my lord. The appeal filed with the insurance company, that has also been
They have
withdrawn, my lord.
discussed, that's why, my lord, we have withdrawn our appeal, my lord.
So you deposit the amount.
Then, my lord, it may be 3%, my lord, not 6%.
No, no, no bargaining. You deposit the amount within 2 weeks from today. Otherwise, face the consequence. Heard, Mr. NC Das, learned counsel for the applicant. Senior counsel assisted by
Yeah.
learned counsel for the applicant, Ms. L. Sharma, learned counsel for the respondent. After hearing learned counsel for both the parties, it is provided that the respondent opposite party shall deposit the awarded amount by the learned tribunal in view of the judgment.
No,
and
just a minute, my,
awarded
the awarded 50% has already been paid, my lord. Along with the interest at the rate of
Okay,
6%.
remaining part of the awarded amount.
That calculation will be
It's
right.
up to, my lord, when they withdraw the amount. Up to withdraw the case, my lord.
Present balance will be, my lord, 19,60,488, which interest up to 26 to 29/5/2026, my lord.
No, not
As per the
26,
calculation
my
sheet, my
lord.
lord.
Not 26, my lord. When they withdraw the
86.
case, my lord, at that time, my lord. it may be
18/6/2010.
calculated,
Along with the interest till the date of withdrawal,
Withdraw 24 to 25.
24,
24 to 2024.
25, within a period of 2 weeks from today, before the registry of this court. List the matter on public status.
Yes, after.
Okay, after vacation.
Okay.
After vacation.
No, all is true.
Okay.
Please, your lordship.
Hmm.
Lordship, as per office note dated 35/2026. On AD card and service report of respondent number 1,
Okay.
respondent number 2 are awaited.
Okay. Heard, Miss,
P. Sharma.
learned counsel for the appellant. Office note dated 38/5/2026 indicates that service report in respect of respondent number 1 and 2, and also the PCR has been awaited. List the matter after 2 weeks, awaiting service report upon respondent number 1 and 2. And Recessal issue urgent reminder for transmitting to the tribunal for transmitting the TCR list after 2 weeks.
My pleasure, Lordship. This IA I have filed for correction, ma'am. Lordship may find it page number 3, para number 2. A and B. Para number 2.
Yes.
In paragraph number 2, instead of Nirche case number so and so, it is to be Miss case number.
Pardon?
In paragraph number 2, instead of Nirche case number 11 of 23, it is to be Miss case number 12 of 25.
12,
12 of 25.
24,
25.
25. Any objection? Heard, Mr. G. Vertas, learned counsel for the applicant, Ms. and Pal, learned counsel for the respondent. This application under section 152 of the CPC is preferred by the applicant for correction of the inadvertent mistake that crept in the order dated 22/4/2026 in the paragraph number 2. Mr. Vertas, learned counsel for the applicant submits that in paragraph number 2, it has been mentioned that the number of the Mizze case is mentioned as Mizze case number 11 of 2023, arising out of title execution case number 11 of 2023. But the Mizze case number O2 have been 12 of 2025. 2025. And accordingly, he is contented to make the necessary correction in respect of the number of the Mizze case. Learned counsel for the respondent submits that respondent opposite party submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that the Mizze case number 11 of 2023 appearing in paragraph number 2 and 3, it is in
2 and 3, ma'am. 2 and 3.
2 and 3. 2 and 3. Henceforth, be read as Mizze case number 12 of 2025 for all purposes.
The reader immediately file our objection in CRP.
No, here it is not necessary.
Yes. William. First time.
Okay.
Delay may be condoned, Lordship, and we'll take steps with speed post only, Lordship. The reasons in para 3 and 4.
Heard, Mr. Agora, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for continuation of delay of 2,572 days in preferring connected MSC appeal against the impugned judgment and order dated judgment and award dated 10/12/2018 passed by the learned member. Motor accident claim tribunal number 3, Kamrup and Gauhati, and MSC case number 1879 of 2013. So notice returnable in forex. Step be taken by speed post and also by usual process within a week from today. List after forex. Lordship.
What is this?
There's a delay in filing FAO. There's a delay in filing FAO,
How many days?
189 days. Notice me.
189. Heard, Mr. Cabra, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 189 days in preferring appeal against the impugned order dated 18/8/2025. Passed by the learned civil judge senior division number 1, Kamrup and Gauhati in Mizze case number 46 of 2024 arising out of title suit number 25 of 2024. issue notice return that be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Kindly fix a date.
May it please your lordship. Your lordship, this matter has come up for the first time. Delay of 3 days in filing the appeal, your lordship.
Part SP Portable, learned counsel for the applicant. This application under section 5 of the limitation act is prepared by the applicant for condonation of delay of 3 days in preparing MSc appeal against the judgment and award dated 17/2/2026 passed by the learned member, Motor Accident Claim Tribunal, Sonitpur in MSc case number 87 of 2024 within bracket D. Issue notice returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Obliged.
Items 48 and 49.
Please, your lordship. Document peruse office note dated 2/6/2025. We have taken steps upon respondent number 5 as per last order and as per office note dated 2/6/2025, unserved notice or respondent number 5 has been received back with postal remark addressee not found. Respondent number 5 is the driver and he did not contest the case in a trial court. His name may be struck off, your lordship, and TCR has been received. Matter may be fixed for hearing.
Part Mr.
S. Sharma,
Learned counsel for the
on behalf of Mr. S.K. Goswami.
learned counsel appearing on behalf of Mr. S.K. Goswami, learned counsel for the appellant, and Mr. Mandal for respondent number
123.
123.
They filed in item number 49.
no. In 106, you are the respondent.
Respondent 123.
Respondent number 123. Office note dated 2/6/2026 indicates that unserved notice in respect of respondent number 5 returned with a report within bracket address is not found. Learned counsel for the appellant submits that respondent number 5 did not contest the proceeding before the learned tribunal, and as such, his name may be struck off from the array of this appeal. Accordingly, taking note of the submission of learned counsel for the appellant, it is provided that the name of respondent number 5 be struck off from the array of this appeal at the cost and risk of the appellant. Since service in this matter has been completed and the LCR has also been received, rest is the matter for hearing after 4 weeks. In MSc appeal number 173, heard Mr. Mandal learned counsel for the appellant. And you are here?
I'm appearing for respondent number 3, the insurance company.
Mr. Sharma, appearing on behalf of Mr. S.K. Goswami, learned counsel for the respondent number 3. Three. So here also service completed? Mandal? Not completed.
Your
Office
lordship,
note dated
in this
to
appeal, the only ground of challenge is that 50% was deducted on account of contributory negligence of the deceased. So only point for determination whether there was contributory negligence or not. So for that particular purpose, I think the presence of owner and driver is not necessary.
contributor negligence.
Contributory negligence.
So driver will be a necessary party.
Yes, your lord.
No, the deceased was also driving a vehicle.
There is a head-on collision, your lordship.
The case was charge sheeted against the vending vehicle, their vehicle. But without
Any evidence on record, whether it's contributed negligence. For example,
No,
Your lordship.
we
then-
can strike off
then
their
I will-
name.
I will strike off the driver, but I will take steps on the owner.
Owner. Owner is respondent number.
Owner is respondent number 1.
So you will take a step upon respondent number,
1 and 2 by usual mode.
usual mode. Okay. Office note dated 2/4/2025 indicates that neither ID card nor answer notice issued to the respondent number 1 and 2 received back by the section till date. Mr. Mondal submits that he will take step upon respondent number 1 and 2 by usual process. Accordingly, it is provided that step be taken by usual process within a week from today, less after 4 weeks, along with item number 48.
Item 50.
My lord, service is complete upon all the respondent except my lord, respondent number 7. 7 is driver, my lord.
7,
My lord, yes.
7.
He is expert in lower court, my lord.
7 is the driver.
Mm.
And
He may be struck over, service
Okay.
may be awaited, my lord.
Service may be awaited.
Service may be awaited.
2022 matter closely. That's the number 8, exam 1R. It is important but choose not to appear. And service is a compulsion. So respondent number 7 is not the.
He may be struck off, my lord.
Okay. Art Ms. L. Sharma, learned counsel for the appellant, and Mr. Khan for the respondent number,
1 to 7 except 3 has already expired.
except 1 to 7. No, 1 to 1 to
So
4,
6.
5 and 6. 5 and 6. Ms. Sharma submits that service in respect of respondent number 7 is yet to be completed. However, she submits that his name may be struck off from the array of this appeal. Accordingly, taking note of the submission of Ms. Sharma, then also at the cost and risk of the appellant, the name of the respondent number 7 be struck off from the array of this petition. No, from the array of this appeal. Array of this appeal. LCR has been received.
Yes, my lord. Yes, my lord.
Okay, kindly better than.
Since the LCR has already been received by the registry of this court, we shall list the matter for hearing after 4 weeks, after vacation.
Obligatory.
Item 51.
Yeah, please, your lordship, as per the last order in respect of ISC 191 of 2026, the statutory deposit already given by the petitioner on 7/4/2026. Now prayer for stay of the demand notice dated 19/8/2024. Petitioner is a widow, my lord, after, during the pendency of the MSCT case, her husband already expired. So she is a widow, my lord. At this stage, it is difficult on the part of the petitioner to pay the awarded amount 50/50. The present petitioner and respondent number 1 was directed by the learned tribunal to pay 50/50 in equal share. That is 19 lakh something, 50,000. 51,000. That is why the prayer for stay of the demand notice. She has no source of income of her own to pay the awarded amount till disposal of the case.
Mr. Bhattacharya?
I'm the insurance company. Did anything more to be done?
Hmm. Hmm.
There is another appeal, pending after Supreme Judgment, is pending before this honorable court. And as per RTI, react with this order.
Hmm.
That is not done, my lord.
Okay, then we'll direct the SC to list both the matter together.
Yes,
Yes, no problem.
Heard Mr. Talukdar, learned counsel for the applicant. Mr. Bhattacharya for opposite party number
number
1 and Mr.
OP number 329 in IA and in appeal 228.
Your name please.
As Ali.
S. Alim for the respondent number 329. Opposite party number 329. Mr. Alim submits that in connection with the same judgment, same impugned judgment and award passed by the learned tribunal, another MSc appeal being MSc appeal number
But I am giving the number.
is pending before this court and both the matters are required to be listed together. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that rest shall list both this MSc appeal number 31 of 2026 and the IA number 191 of 2026 and MSc appeal number you furnish together after 1 week.
Lordship. 329, my lord. 329. Deep down.
Item 52. May I please, Your Lordship? My lord, in this case, Lordship, we have filed an appeal for enhancement of award. Lordship, your Lordship has admitted this case and TCR was called for. Accordingly, TCR received. In the meantime, Lordship, the awarded amount has already been deposited before the tribunal. And because of non-availability of record, they are not disbursing the amount. Lordship, I am praying by this IA Lordship that the record may Lordship send back and may recall again after disbursing the amount. Lordship.
No, instead of sending back the record, we can direct them to open one supplementary file and to release the amount.
Yes, that can be if your Lordship, but we have prayed, but they are not doing that. If your Lordship direct that, they will prepare a supplementary record.
Only for releasing the amount, the record is not required to be sent.
Yes, yes.
Heard Mr. M. Khan, learned counsel for the applicant. This application under section 151 of the Code of Civil Procedure is preferred by the applicant for returning the record of MSc case number 98 of 2023 to the learned member Motor Accident Claim Tribunal Boingao for disbursement of the awarded amount. Mr. Khan, learned counsel for the applicant, submits that the applicant has preferred one MSc appeal being MSc appeal number 25 of 2026. And the same is pending before this court for hearing. And the LCR has also been received. And in the meantime, the respondent struck opposite party has deposited the awarded amount before the member, learned member Motor Accident Claim Tribunal Boingao. But the said amount could not be disbursed by the learned member on account of non-availability of the MSc record of MSc case number 98 of 2023. In view of the submission of Mr. Khan, learned counsel for the applicant, and also considering the facts and circumstances on the record, it is provided that the learned member Motor Accident Claim Tribunal Boingao Cell open one supplementary file and thereafter release the awarded amount in favor of the applicant. In terms of above this, I stand this will.
Item 53.
Maybe. Lordship, we made a inquiry in the circle officer and applied for the copy of a trace map. But since circle officer was on leave till 5th of June, so we could not obtain the certificate copy of trace map. The other thing is that today I filed one affidavit, but that is not tagged till now in the record. So. I don't know. It may be taken up by
Let
two
it be in the next week.
Lordship, matter is fixed on 6th, and the police is insisting for pursuing this order. So my prayer is that till then we may be protected, Lordship. It is the big problem here, Lordship. Otherwise, the filing of this appeal will be infructuous.
Submit the matter is on fixed, Lordship. And both the parties are already before the court with their relevant submission, Lordship. Then they appear before the court on the 6th, and the injunction order is only till 6th, Lordship. It is not until party or further order. So on the next day, if they have the relevant documents, they appear to trial court and produce the document. Definitely the trial court, if they have relevant documents, will not extend the injunction order, Lordship. So if the parties are already there, there is no way keeping the suit pending, in the mistake is pending, Lordship. So better let the, if they are agreed by the final injunction order passed by the trial court, they may definitely come before this honorable court with their grievances, Lordship. But as of now, it's just an interim order passed by the trial court, Lordship. So that is only 2 days, Lordship. On 6th, the order will expire, Lordship, if they seek an objection for its extension. So on this circumstance, my humble submission, Lordship, better it is for both the parties, since we have copies have already been served, they have already prepared the documents. Let both the parties appear before the trial court on 6th, Lordship.
Lordship, till then he may give a assurance that the parties should not be evicted from the areas.
This is an order.
And then even we are ready for that. Otherwise, he cannot make such a submission before this court.
That is my suggestion, because Lordship, after an injunction order was passed, as a bona fide citizen, Lordship, my duty is always to obey by the order of the court. We always have the provision that against this order, I will come before higher authority or before the tribunal seeking for setting aside of the said order. But despite there being an order, if I willfully violate, definitely the tribunal will pass an order for directing the police to enforce the order, Lordship. So it is what is happening in this case, Lordship. There is an order, they knew about the said order. It was their duty to come before this, either before this honorable high court or before the trial court, Lordship. But sticking that, but during this period, they should have abide by the order. It is a judicial order after all, Lordship. Otherwise, there is no value of any injunction order passed by any trial court, Lordship. But during this entire, even today, my petitioner friend cannot submit that they are not violating the court's order, in spite there being no stay granted by this honorable high court, Lordship.
We are challenging that order and not applying it.
Lordship. But the
We are challenging. Why? Where is the question of obeying?
So my submission for this honorable court, Lordship, is there is no stay granted, Lordship. And the honorable court has directed them to produce some document to prove that it's public document, public road. Had they been produced it, and the court has set aside, there have been no restriction upon them, Lordship. But they, despite knowing that there is no stay being granted by the honorable high court, Lordship, they have been still violated as on today. They cannot say, given an affidavit, that they are not today, as on that they are abiding by the order passed by the trial court or by the direction given by the honorable high court, Lordship. So there is no bona fide attempt on the part of the petitioner, Lordship. I am giving an assurance that if today they give on record some documents, so it's a public document, we will not ask the police or the tribunal to enforce the order until it is finally executed by the trial court. But it is also their duty as a petitioner or a citizen of the court.
No, Mr. Ali, you say the person concerned is on leave. Person concerned is on leave. He will be available on
5th, Lordship.
5th.
Yes.
But the matter is fixed on 6th.
6th, Lordship.
Immediately on next case, Lordship. Once on subsequent date, the court is a trial matter is on fixed on.
The police has told the parties that if we cannot bring any stay order today, then they shall vacate us, Lordship. That is the latest information, Lordship. Therefore, some protection is necessary, Lordship, because the Masjid Gully, it is still in dispute. We are saying that this is a private road, not a private road. It is.
But Mr. Sharma, can you produce the document on 8th? Monday?
Yes, Lordship. We can.
Monday. Okay, till then you don't try to enforce the order.
We are not enforcing, Lordship. That's what I am submitting, Lordship. Even today they are sitting on the road there. Had we been using hired goons or some, Lordship, then we have not used our.
Okay, till then maintain the status quo. Heard Mr. Sharma, learned counsel for the applicant. And also heard Mr. Ali, learned counsel for the respondent, opposite party number 1 and 2. Mr. Sharma submits that though he was directed by order dated 1/6/2026 to produce relevant document before this court today, so as to demonstrate that the applicant herein are doing business on a PWD road. And accordingly, he has applied for the relevant document to the circle officer. Which circle?
Guwahati Circle.
Gauhati circle. But the circle officer is on leave till 6th of May. 5th of May.
He will be
5th
available
of
on
May. Sorry, 5th of June.
5th of.
And as such, the document could not be produced before this court, and if placed for listing the matter on 8th of June. They are allowed. And after hearing both the parties, it is provided that till then, the order dated 6/5/2026 shall not be given effect to. Shall not be given effect to till Monday.
Because on 6th December, if they have the liberty, let them file it or written objection if they wish to.
We shall file, Lord. So we shall file it on that day.
I beg lordship's pardon, my lord. In item 51, by mistake, I have submitted that another appeal is pending. So my lord, my friend is there. So that part may kindly be called. My lord.
The number which he has given, it is my case, my lord. It is not the appeal, it is the MSC case number of trial court.
Okay.
So demand notice may be kindly stayed, my lord.
Pardon?
Demand notice may kindly be stayed, my lord.
On next day, we will take call of. Next date.
After one week.
Items for admission. Item 1, parted matter.
May I be lordship? Okay, before I start, I'd like to set out the brevity of the facts, lordship, first. Matter pertaining the provincialization of the school, lordship. So here in lordship, the school has provincialized, lordship in the year 2013, lordship. And that part is clearly reflected page 26, lordship, and find out page 26. The Rajiv Gandhi LP School, Thekiya Lordship. And herein lordship reflecting serial number 9, lordship. And defined lordship page 2. The Rajiv Gandhi LP School, lordship. So herein clearly defined lordship as per the section 3, subclause 3 of the 2011 Act, lordship. So can define lordship in an education manual, lordship. So on that basis, lordship, the school as provincial, lordship, can define lordship. Section 3, subclause 3, lordship. His lordship 561, lordship. Lordship.
The earlier act.
Yes, lordship, earlier Act, lordship. Is a
561.
Yes, lordship. Section 3, subclause 1, lordship.
Yes.
Clause 1, lordship, the subject to the provisions of Article 30 of the Constitution of India, the following categories of the venture educational institution shall be eligible for being considered provincialization of the services of its employees. Clause 1, lordship, kind of. The venture educational institution which have been established and obtain the required permission of the recognition application occurrence as the keys may be from the respective competent authority and authorities on or before 1/1/2006, lordship. So, lordship, on that category stated, lordship, the school has provincialized, lordship, in the year 2013, lordship. So after following the some said relevant paragraphs, lordship. So lordship, close to, lordship, can define, lordship. It has minimum total enrollment of 25 students. It is the primary school, both the lower primary and upper primary school, lordship. So here, lordship, is a clear defined, lordship, the after perusal, the all records lordship, the authority concerned has provincialized the said school lordship. So now lordship, kindly find lordship. After 1 year's lordship, the school provincialized had withdrawal lordship.
Hmm.
Withdrawal is page 35 lordship. In my repetition lordship.
Yes.
So herein lordship, the first paragraph lordship, the provincialization is under issue by the office order memo nong so dated 13/5/2013 in respect of the Rajiv Gandhi LP School is hereby withdrawn due to the non-availability of the dice code as per the office record lordship.
Hmm.
Not record of the dice code lordship as per the office, but lordship, the respondent number 5 lordship is a DEO, is clear defined lordship, the page number 35 lordship can define lordship in the my repetition annexer 6 lordship, page 37 lordship.
Hmm.
Kindly find lordship, page 37 lordship.
Hmm.
Merit lordship. With reference to the subject cited above, I have the honor to
No,
request.
Mr. Das, not necessary to read out. So as per this letter, the school has a dice code.
Yes, lordship. 2009 and 10 lordship.
Hmm.
So the authority concerned says lordship, the note record of the dice code lordship. So herein lordship, the respondent number 5 himself categorically stated lordship in this annexer lordship. He's a block elementary education officer lordship. Is the academic session 2009-10, 2010-11, 2011-12, 12-13, and 2012-14 as per guideline under the block elementary education office Dhekiajuli lordship. And herein lordship, the dice code of school item 18110205 lordship. So that letter issued by the BEO dated 13/2/2014 lordship. So concerning lordship 2009-10 lordship, and that part has clearly reflected by the concerned authority issued in this letter lordship.
Hmm.
So due to this non-availability of the dice code, the school has disqualified as a provincial lordship. So the respondent number 5, block elementary edition himself.
Mr. Gogoi, you have filed a affidavit here?
Yes, sir. Two affidavit. In fact, my lord, in the initial affidavit, we have given the entire procedure, how my lord, this dice data is controlled. What was the position before 17 and 18 and subsequent to 17 and 18. Everything has been explained. And my lord, apparently even today, the court says that in 9-10, my lord, the petitioner doesn't have the dice. Apparently. And this, my lord, in fact, the education department, in fact, in the initial affidavit, has taken the same step.
And lordship.
No, but this page number 37, annexer 6.
Yes, lordship.
Yes,
37.
37.
yes. Sir. Here, my lord, so far as this 9-10 is concerned, my lord, in the affidavit we have stated data capture format, that is a format, my lord, filled up by the school, my lord, and it is submitted to the concerned authority. Only that form has been, my lord, annexed in the report. And relying upon that, my lord, this report was submitted. That is not the, my lord, dice data. In fact, my lord, petitioner got the dice data from 2010-11. Not from 9. That's because, my lord, a particular school, in order to have the benefit of the provincialization, have to have the dice data from 9 and 10. That was, my lord, manufactured in the to create the confusion and to get the benefit of, my lord, one document, which actually has not been issued by the authority, or well, it has not been uploaded in the concerned portal of dice data. In fact, also you will see the number also, well, doesn't tell you. The one that the petitioner, well, is annexed in the petition, this particular data format. Also you will see page 18.
18.
Yes, 1 and 18.
That part already initially several times argue in this matter, Lordship. So, Lordship, the hearing Lordship, the respondent authority, respondent 5 Lordship, himself category state Lordship, the dice code record is available Lordship. So, let the file affidavit Lordship, the respondent 5 Lordship.
Then Lordship is seen.
So, initially, they did not raise this query against that respondent
Page 80.
annex of 6 Lordship.
Got it.
305, last 3 digit.
Mm.
Now, Lordship will see page 101 filed by the service officer. 101.
Hmm.
Lordship will see, my lord, here the dice code. It there from 2011, 12/13 we have an next panel.
Hmm.
And page 100, Lordship will find, my lord, the school report card is from 2010 and 11. Page
No,
100.
Mr. Gogo, you see, is there any discrepancy in respect of the dice code?
The dice code, my lord, it appears, my lord, 18110, probably this is one number.
Hmm.
And 205305, my lord, is the main code. Yes. So that part is there. What I'm saying is, my lord, this particular document at page 99, part of my affidavit also, has been prepared by the petitioner just to show that, my lord, he comes within the zone of consideration as per the rule for provincial election. For the act of 2017. But the criteria is, my lord, they will have to have the dice code from 9, my lord. This particular page was, my lord, filled up. Lordship will see next page at page 100. At the top, Lordship will see school code number so and so, Rajiv Gandhi LPS. It is from 10 and 11. Our records speak that, my lord, from 10 and 11, this is available. This particular document at page 99 will have to be accompanied by a school report card, as in page 100. And that report card is available only from 10 and 11. And based on this data, my lord, it is uploaded in the dice data. Everything, school teachers, how many students are there, what is the furniture, what is the, my lord, area of the school. Everything is there, my lord, in this particular data. And that data has been furnished only in 2010 and 11.
These documents are very much illegible, Lordship. 110, my friend Lanet query, Lordship. This page is very much illegible, Lordship.
And, my lord, page 105, my lord, entire school, my lord, list of schools, my lord, which are available in our website. For the period of 2009 and 10, we have, my lord, NST. The name of the school of the petitioner does not appear in this list. You will see page 100 over 105, Annexure B of our affidavit. At the top, list of schools under Sonitpur district as per DICE 2009 and 10. The name of the petitioner school is not there in the chart. From 10-11, it is there. There is no dispute regarding that.
And basic things, Lordship. So here in my friend Learned Counsel did not raise any kind of the query in regarding this Lordship, the annexure 6, the BO letter, Lordship. They did not manifest any kind of the query before the affidavit filed by my friend, Lordship. The 37 is a very relevant, Lordship. So that's why I raised this query, Lordship. So not a single point has raised in this affidavit, Lordship. Their affidavit. So this is the vital document, Lordship. So because the authority himself admitted and herein something different, is a discrepancy, Lordship.
On this particular document at page 37, we have sought for clarification from the district elementary education officer, Sonitpur test board. He has responded, it is at page number 94. With reference to the subject cited above, I have now to inform you that so and so there is a petitioner herein, is working at Rajiv Gandhi LPS, having DICE code number so and so under the jurisdiction of Block Elementary Education Officer Dekiazuli, which was provincialized by the District Elementary Education Assam, Director of Elementary Education Assam, by order dated 14/5/2013 with effect from 1/1/2013. But the said provincialization order has been withdrawn by the Director Assam by order dated 1/2/2014 on the ground of non-availability of dice code as per the Director of Elementary Education Assam's office record. It is to be mentioned here that as per school report card 10 and 11, I placed my lord already page 100. It is found that the concerned school received its dice code during the year 2010 and 11, bearing dice code number so and so from NIPA, New Delhi. But the school authority, headmaster of the school, Mrs. Mumtaz Begum, that is the lead petitioner, furnished only school data capture format showing dice code bearing number so and so for the academic year 9 and 10. At the time of submitting the particulars of the school for provincialization in the year of 2013, my lord. That document was, that's why I'm saying it is a manufactured document, was furnished in 2013, last to come within the zone of consideration. From 10 and 11, it is there, it is has been a position.
So
By
here,
just typing, my lord, this particular data format of 2009 and 10, he cannot claim that, my lord, I have got the dice data of my lord, from 2009 and 10. Because, my lord, he has got that, my lord, number, dice number, my lord, in 10 and 11. He is aware of this number. So he has typed it in a form of, my lord, 9 and 10, claiming that I have got the dice data. Whereas, my lord, dice data was issued in 2009, 10 and 11. That is our record, my lord.
so here in the same date, lordship, that document is subsequently prepared by the authority concerned,
No,
lordship.
we have for
So,
verification, we have shown the affidavit, my lord, it is there.
So here in lordship,
Page number
lordship,
85,
here in,
para 3.
here in
Yeah,
date,
mention-
lordship, 13/12/2014, and the subsequent lordship, my friend submitted lordship,
Page
23/12,
85 of the
2020
APSL
lordship.
by-
Very discrepancy, lordship, here in lordship.
as by respondent number
Subsequently,
7, my lord.
So,
If
lordship,
you want to file affidavit denying all this, there's a different issue, but then again, there will be a disputed question of fact. How can this be ascertained by the number of court? Our stand is very categorical. In two affidavits, we have stated that it is from 10/11 that we have got the dice data. That is what the record speaks. That is what the portal says.
So the school was provincialized in the year 2013.
yes, lordship.
Earlier,
Earlier,
earlier.
13. Then subsequently, her provincialization, the provincialization was cancelled from the school.
When
On the
it
ground
was
that
when it was cancelled?
Yes,
Cancel lordship,
it was cancelled on
1/2/2014 lordship, page 35 lordship.
Yes,
yes,
35.
1 to 2014.
Only reason behind the dice code, the record is not available, lordship. And lordship, here in the swing order passed by the director lordship, the page 42. Here is nothing mentioned in this swing order, lordship. Page 42, lordship also. Kindly find, lordship. This is the SSA and the RMSA.
So the question is under which side her case ought to have been considered?
Well, she will not come under the
The
zone of
lordship-
consideration as per the provisions of the act and the rule. That's the position.
And lordship will do that.
Because it is pursuant to act that, my lord, that provincialization act was carried out. So subsequently, my lord, the entire act was kept. With the, my lord, direction that, my lord, whoever has been provincialized, they will not be disturbed, but there will be no further provincialization. Subsequent to that, the 2017 act was, my lord, enacted.
Mm.
Lordship will do the back, lordship. So here in lordship, the swing order passed by the lordship, SSA lordship. Kindly find page 42, lordship.
Page number?
40. Swing order passed by the authority concerned SSA lordship.
Page number?
Page 42, lordship, Annex 8, lordship. Page 42, lordship. Kindly find, lordship. So here initially read petition was there, lordship. The read petition directed, lordship, 17/11/2020, lordship.
So, Mr. Gogoi, you see, under the earlier act, there was no requirement of dice code.
No, my lord, that part has been, my lord, that act has been totally unconstitutional.
Pardon?
That act has been already set aside by the honorable.
No, that's all right. There is no dispute about
Yes.
it. No dispute about it.
No.
Have you gone through the provision of section 24 of the new act?
Well, well, that was, I said, no, it will be protected, my lord, whoever has been regularized will be protected.
Mm.
protection is.
So her service was regularized, provincialized in the year 2013,
Yes. In the
and
first-
it was cancelled in the year 2014.
No, my lord, eligibility part will come in, my lord, otherwise.
Eligibility part will
Yes,
come in.
yes, sir.
No, the requirement of subsection 1 to section 4 of the earlier act.
Lordship. That is the 2011 number.
Mhm.
561.
So by operation of laws, her service deemed to have been provincialized.
My lordship also said that, my lord, since that criteria was not there in 11.
Hmm.
So the round of rejection on the point of 9 and 10 will not come. But my lord, the act itself is not there. Now it is.
May not be there, but you see the section 24 of the new act.
17.
The Assam Welfare Educational Institution, Provincial List of 2011, as amended by the Assam Welfare Educational Institution, Provincial Service Agreement 2011, and the Assam Welfare 2013, which has been struck down by the further notification which would denote that it's liquid. However, teachers whose services were provincialized prior to 23/9/16 shall continue and acceptably reviewed as per the. Now, we see now last line.
Hmm.
And their cases, they will be protected.
Hmm.
Lordship will see last
Yes.
third line.
Hmm.
Of course, however, Lordship will see the last fourth line. However, all the teachers. Page 126. However, all teachers whose services were provincialized prior to 23/9/2016,
Hmm.
they'll continue. And their cases shall be reviewed, my lord. It will have to be reviewed as per the eligibility norms set forth for provincialization under this act. So 9 and 10 will automatically come in, my lord.
Hmm.
So it will, the direction was that all who have been provincialized will have to be reviewed under the provision of the new act. If they fulfill the criteria, their provincialization stays, or else, my lord, even if the provincialization was made prior to 2015, that is the date of 23/9/2016.
Yes, her service was provincialized earlier, in the year 2013.
Yes, Lordship.
13.
Yes.
So under which act her case shall be considered?
Saving clause says that since, my lord, the earlier act has been struck down, whoever teachers were already provincialized under the earlier struck down, my lord, act, they will continue. But, my lord, their services will have to be
Mr.
reviewed.
Gogoi, there is a decision of coordinate bench of this court on this point. Justice Buzarbaro has delivered
Yes,
the
Lordship.
judgment.
Lordship. Johnny, sorry.
Is
Lordship.
it available with you?
Yes, Lordship. I have copy, Lordship.
Then pursuant to that judgment, the petitioner of that writ petition was appointed by the respondent authority.
Is a Doneshwari ME School, Lordship. Judgment dated 15/2/2022, Lordship. Paragraph 2 is made. Category defined of para 2, Lordship, basically.
Let us do one thing. We'll fix the matter on Friday. You come prepared.
Yes. Yes.
Heard, Mr. Das, learned counsel for the petitioner, Mr. Gogoi for the respondent number. Gogoi, you are for respondent number 7. Mr. Pokon for respondent number 1 and 2. Madam, you are here. Ardin part, list the matter on Friday.
And Lordship, section 58 of the Evidence Act, Lordship, if once admitted of facts, does not require the subsequently proved, Lordship. So
that is there.
Yes, Lordship. The Supreme Court has lots of judgment, Lordship. Yes, much of that.
Professional PSA.
May I please, Your Lordship? Lordship, on 15 May 2026, we filed an affidavit. Against that, my lord, on 3rd of June, the respondents have filed an affidavit. Neither of the affidavits are on record. So that may be tagged along.
But, no, we say that affidavit filed by them is not very relevant in this revision petition. Bringing some subsequent development, but then, since they filed it and it is on record, let it come along with this affidavit, on Monday, because we have some urgency in this.
Okay, on Monday.
Monday.
Heard, Mr.
H.K. Sharma.
Learned counsel for the petitioner, Mr. P.K. Roy. The learned senior counsel assisted by Mr. Gusami. Learned counsel for the respondent. It is submitted at the bar that both the parties have filed their respective affidavit, but the same are not placed on record. And as such, it is submitted that the matter may be listed on Monday.
Yes, sir.
Along with the said affidavits. Accordingly, it is provided that Registrar shall list the matter on Monday and take the affidavit filed by both the parties with the record. This caveat was filed by whom?
But we have filed, in fact, history has a note, says by mistake this was not placed.
Okay, caveat will be heard, caveat is research. Monday.
My lord, there is an interim order.
Interim order pass earlier shall continue.
Much.
Till the next day.
Till the next day.
Item number 3.
You were for the respondent.
Yes, right.
So Mozumdar was there. Kabe. Petitioner. D. Mozumdar was there. Okay, after 2 p.m.
Item number 4 by VC vote.
Relationships.
Yes.
May it please the lordships.
Yes.
I hope I'm audible, lordships.
Yes, you are audible.
Yes, lordships. Now, lordship, this is an appeal. The petitioner before your lordships is the People's Arm Wrestling Federation of India. It is a company under Section 8 of the Companies Act 2013. We are aggrieved by a ex parte ad interim order of injunction passed on 13/5/2026. Now, if I may briefly tell lordships, the plaintiff, who is the respondent before this court, has filed a suit assailing two orders. Essentially, it's a suit for defamation and compensation, assailing two orders. The two orders are Annexure D, page 90, and Annexure E, page 91. These are the two orders which has been assailed by the plaintiff before the learned trial court. Now, lordships, the trial court, learned trial court on 13/5/2026 has passed an ad interim ex parte injunction order against us, which we are aggrieved of, and therefore we have approached this court in appeal. Now, I want to make three quick points, lordships, why this order is prima facie on the face of it wrong and cannot stand. But lordship, kindly take. The first point is the impugned order violates the mandatory provision of Order 39, Rule 3. The first point is the impugned order violates the mandatory provisions of Order 39, Rule 3. The second point of challenge is the petitioner has acquiesced. If lordship will appreciate, the one of the orders he is challenging is of 29th of September 2025. And he has challenged it by filing a suit in April 2026. So having acquiesced, he is not entitled for an ex parte ad interim injunction. That is the second point. And the third issue, Lordship, is what he has challenged is a official communication, communicating an order suspending him. The order suspending him, which is the parent order, has not been challenged. What is challenged is communication by the respondents, communicating his suspension by the world body. So the parent order is still not under challenge. Now, if I may take your lordships one by one to my first submission. And if lordship is satisfied with my first submission, lordships may not even. Now, would lordships kindly for a moment take order 39 rule 3 of the CPC? Though lordships read it, but for my satisfaction, if lordships can take it upwards.
Yes.
Let's order 39 rule 3, lordships.
Yes.
Before granting injunction, court to direct notice to opposite party. This court shall in all cases, except when it occurs that the object of granting the injunction would be defeated by delay, before granting an injunction, direct notice of the application for the same to be given to the opposite party. But there's an exception, provided that where it is proposed to grant an injunction without giving notice of the application to the opposite party, the court shall record the reasons for its opinion and that the object of granting injunction would be defeated. Let us stop it at here. So therefore, an obligation is cast upon the court that when you are passing an ad interim ex parte order, you must record reasons why it is necessary. And this provision has been interpreted by the Supreme Court to be of mandatory in nature. Now, please have a look at the impugned judgment. Not even a word has been recorded with respect to this part. Would lordships kindly come to the impugned order? Annexure A, page 33. And kindly come to page 38 from where till page 38 from where the findings and conclusions of the trial court starts, lordships. Para 6, lordships, page 38.
Yes.
Learned counsels for the petitioners and gone through the pleadings in the main suit as well as the documents. It is evident that 3 fundamental principles are to be satisfied for granting ad interim injunction, that is prima facie case, balance of convenience, and irreparable loss and injury. Then, lordships, the court discusses what is prima facie case, then it discusses what is balance of convenience, and then it discusses irreparable loss. Now, lordship will come to para 7. Now, para 7. Now, on the backdrop of the above understanding, decide the prima facie case, balance of convenience, and irreparable loss and injury in the context of the present case. Then, lordships, the court discusses prima facie case. It extracts the facts of the case again, and then at page 43 directly, lordship will come to page 43. All this is extracting the case of the plaintiff. Kindly come to page 43. The last line of the first paragraph. From the above contention, it is evident that the plaintiff has a prima facie case in his favor. No problem, lordships. Then, lordships, the court goes on to see the balance of convenience. The learned counsel for the plaintiff has further submitted a continued circulation of defamatory statements branding the plaintiff as blacklisted, banned, and engaged in illegal activities has already resulted in loss of collaborations, social boycott, reputational harm, mental agony, and erosion of professional opportunities across multiple jurisdictions. At this stage, if there is no interference by this court, then the plaintiff will be at more disadvantageous position compared to the defendants. Hence, the balance of convenience is in favor of the plaintiff. Then, Lordships, the court goes to discuss about irreparable loss and injury. And Lordship will turn over the page. And in the middle of the paragraph, there is a statement that starts the defamatory publications, if Lordships can find that.
Yes.
This is the finding of the court. The defamatory publication and actions of the defendants constitute a continuing wrong and recurring cause of action. Unless restrained by an order of injunction, the defendants are likely to continue causing irreversible injury to the plaintiff's reputation and career on a day-to-day basis. It is evident from the above facts and circumstances, if at this stage there is no interference from this court, then there is a possibility that the plaintiff will suffer irreparable loss and injury, which cannot be compensated with money. Moreover, there is a possibility of multiplicity of proceedings in the event of non-interference by this court. Then we will come to the next page. Therefore, in my opinion, all three golden principles of law of temporary injunction are lying in favor of the petitioner. Now, that is all. There is not even one reason why this order had to be passed ex parte. Now, Lordship will see how this provision has been interpreted by the Supreme Court and what entails this violation. Lordship will know, but I may just place two judgments on this. Violation of it renders the order void. Now, kindly have a look. If my colleague can hand over. Shiv Kumar Chadda is a three-judge bench, 1993, 3 SCC 161. 1993, 3 SCC 161, Shiv Kumar Chadda. And may I draw your Lordship's attention straight to para 34 at page 18. Para 34. 34-35, they expound the law on this. And this judgment is holding good till now. Para 34, Lordships.
Yes.
Now they are interpreting that proviso which Lordships, I had shown Lordships that the court can still go ahead with an ex parte ad interim injunction provided it records reasons. I had shown that, Lordships. Now the court is interpreting the proviso to Order 39, Rule 3. The imperative nature of the proviso has to be judged in the context of Rule 3 of Order 39 of the Code. Before the proviso aforesaid was introduced, Rule 3 said the court shall in all cases, except when it appears that the object of granting the injunction would be defeated by the delay, before granting an injunction, direct notice of the application for the same to be given to the opposite party. The proviso was introduced to provide a condition where court proposes to grant an injunction without giving notice of the application to the opposite party, being of the opinion that the object of granting it shall be defeated by delay. The condition so introduced is that the court shall record reasons why an ex parte order of injunction was being passed in the facts and circumstances of the particular case. In this background, the requirement for recording the reasons for an ex parte injunction cannot be held to be a mere formality. This requirement is consistent with the principle that a party to a suit who is being restrained from exercising a right which such party claims to exercise either under a statute or under common law must be informed why, instead of following the requirement of Rule 3, the procedure prescribed under the proviso has been followed. Now, Lordships will come, then Lordship, the party which invokes the jurisdiction of the court for grant of an order of restraint against a party without affording an opportunity to him of being heard must satisfy the court about the gravity of the situation, and the court has to consider briefly these factors in an ex parte order. Now, Lordship will then, the court goes on to discuss judgment and kindly come to para 35. What does the court say?
Yes.
As such, whenever a court considers it necessary in the facts and circumstances of a particular case to pass an order of injunction without notice to the other side, it must record reasons for doing so and should take into consideration while passing an order of injunction all relevant factors, including as to how the object of granting injunction itself shall be defeated if an ex parte order is not passed. I rest my case, your lordships. So therefore, in the face of a straight violation, and this lordship will kindly see the next judgment on this point, which reiterates is this latest judgment, 2025 SCC Online SC 1674, that is Time City Infrastructure. If my colleague can hand over that. This principle has been followed all through. Would
Mr.
lordships kindly
Goswami?
come to para 4?
Mr. Goswami, you will
Lordships?
resume at 2 o'clock.
Yes, lordship, certainly, lordship, certainly. I am so grateful. Judgment I had shown, I had to place one more passage which missed my attention. I had placed para 34 and I had read up till, if lordship will turn over the page, I had read up to the fourth line in the ex parte order. After that, I want to place it if lordship will see that, but very important. I should have placed it earlier. We are quite conscious of the fact that there are other statutes which contain similar provisions requiring the court or the authority concerned to record reasons before exercising power vested in them. In respect of such provisions, it has been held that they are required to be complied, but non-compliance therewith will not vitiate the order so passed. But the same cannot be said in respect of the proviso to Rule 3 of Order 39. The Parliament has prescribed the particular procedure for passing an order of injunction without notice to the other side under exceptional circumstances. Such ex parte orders have far-reaching effect. As such, a condition has been imposed that the court must record reasons before passing such order. If it is held that the compliance with the proviso aforesaid is optional and not obligatory, then the introduction of the proviso by the Parliament shall be a futile, and that part of Rule 3 will be a surplus for all practical purposes. Proviso to Rule 3 of Order 39 of the Code attracts the principle that if a statute requires a thing to be done in a particular manner, it should be done in that manner or not at all. This principle was approved and accepted in well-known cases of Taylor versus Taylor and Nazir Ahmed versus Emperor. This court has also expressed the same view in respect of procedural requirement of the Bombay Tenancy and Agricultural Lands Act in case of Ramchandra Keshav versus Govind Jyoti. I wanted to place this passage, which I should have placed earlier.
Okay.
That in respect of order proviso to the Order 39 Rule 3, it cannot be said to be it cannot be said to be not mandatory. It is obligatory and mandatory. That is the distinction the court carved out with respect to this proviso. So why this proviso is so important and why it needs to be followed when an ex parte order is passed.
Okay. Any other
will
point?
come to the pardon, lordships.
Any other point?
Yeah, the other judgment I had shown, lordships. Time City, which reiterates the same position. I will not read it. It relies on this judgment. And lordship will just mark the paragraphs, para 4 to 6. I will not read it. It relies on Chadda's judgment and reiterates the position that this is mandatory and needs to be followed. Otherwise, the order stands vitiated. Para 4 to 4, 5, and 6. In fact, para 4, it extracts Order 39, Rule 3. Para 5 is a discussion, and para 6 is where the court relies on Shiv Kumar Chadda. Okay. In fact, if I just place para 5, only para 5 for lordships, the discussion of the court. Looking to the scheme of Order 39 CPC, it is clear that ordinarily an order of injunction may not be granted ex parte. The opposite party must be issued a notice and heard before an injunction may be granted. Rule 3 carves out an exception in favor of granting an injunction without notice to the opposite party, where it appears that the object of granting injunction would be defeated by delay. Conferment of this privilege on a party seeking an injunction is accompanied by an obligation cast on the court to record reasons for its opinion, an obligation cast on the applicant to comply with the requirements of clause A and B of the proviso. Both the provisions are mandatory.
Okay.
So this is my submission on the first point I made. That this order on the face of it cannot stand even for a day, because there has been a clear violation of order 30 of the proviso to order 39 rule 3. Lordship have seen that impugned judgment, which doesn't
what is
discuss, not even a word has been discussed.
What is the next? What is your next point?
Yes. My next point, Lordship, is the Lordship will appreciate that the plaintiff has assailed two orders. One order is of 21/9/2025, and the other one is of 26/4/2026. A 21/9/2025 order is suspended by the court in April without demonstrating any urgency. And from 21/9/2025, he was keeping quiet. So he essentially acquiesced. So once acquiescence is proved, the person is never entitled to an ex parte injunction order. That is my second submission. For these lordships, and directly on the point, would my colleagues hand over this another celebrated judgment, Morgan Stanley. This is a 3-judge bench judgment.
Okay, that is a
1994.
Yes, very old judgment.
Very old judgment, lordships. Very, very old judgment. Para 36 is what I'm relying on. If lordship will kindly come straight to para 36, a very celebrated judgment. Everybody knows about this. I'll just reiterate it, so lordships. Para 36.
Okay, I will go through the same. You come to your next point.
My third point is, lordships, kindly have a look at the orders he has impugned. Kindly have a look at Annexure D, page 90.
Yes. Yes.
Now, kindly mark the date. It is 21st of September 2025.
Yes.
And the suit is filed in April 2026. Now, what does this order say, lordships? Directive regarding Ryan Bowen, who is the respondent before your lordships. Dear Sir, Madam, as discussed in the PAFI governing body meeting held on September 20th, 2025, it has been brought to our notice that Australian arm wrestling athlete Ryan Bowen, currently in India, has been indulging in anti-PAFI activities. He has been misguiding and manipulating PAFI athletes for both personal and professional purposes, as well as attempting to create a division within PAFI. It has also come to our attention that he is attempting to run illegal arm wrestling seminars and classes in India, allegedly charging athletes for the same and allegedly without possessing a valid work permit for India. Further, it was highlighted that Mr. Bowen has created several issues in promotions worldwide, including in his native country, Australia. His name was also allegedly still present on the WAF suspended athletes list as of September 19, 2025. In view of the above, it was unanimously decided in the governing body meeting that all state associations, district associations, affiliated clubs, and PAFI athletes are hereby instructed to refrain from any form of engagement, collaboration, or association with Mr. Ryan Bowen effective immediately. Any violation of this directive will result in strict disciplinary action. we request all concerned to take notice of this directive and ensure full compliance. This is the first order which the plaintiff has challenged. Now, Lordship will see the second order, which is at page 91. Now,
Yes.
before I place this order, kindly appreciate that this is a communication by the petitioner before your lordships to the state associations communicating the decision of the parent body, and that decision has not been challenged. Kindly have a look at this communication. To all state presidents, secretaries, People's Arm Wrestling Federation of India, subject official intimation regarding WF suspension of Mr. Rawen Bowen and Chetna Sharma from all WAF international events. Sir, madam, this is to formally inform all state units that the People's Arm Wrestling Federation India has received official written communication from World Arm Wrestling Federation regarding disciplinary action taken at the international level. As per the communication, Ryan Bowen has been suspended by the World Arm Wrestling Federation from participating in all international arm wrestling events and WAF sanctioned activities under further notice and has been put in the list of athletes in not good standing. I will just pause for a moment. So Mr. Bowen is in the knowledge that he has been suspended by the parent body. Despite being in the knowledge of this, he chose not to challenge this order of the world body. The suspension of Mrs. Chetna Sharma by People's Arm Wrestling Federation of India has also been formally accepted and recognized by the World Arm Wrestling Federation and will now be enforced at the international level. And she will not be eligible for any WF events or WF sanctioned activities during her suspension period. All state associations are hereby directed to inform all affiliated players, coaches, referees, and officials within your respective states about the above decision. Ensure strict compliance with WF activities in all national and international representations. Refrain from nominating, recommending, or supporting the participation or attendance of above mentioned individuals in any event governed or recognized by PAFI or WAF. That is all. We are communicating a decision of the world body to the state associations. Now, what is the communication? Which the original communication is on page 105. This is the communication we received from the world body, which has not been challenged by the plaintiff. May I just place it, lordships? Dear Preeti, she is the president.
No, Mr. Goswami, not necessary because we are not hearing the matter on merit. We are only
Yes.
examining the impugn order.
Yes, yes.
Not necessary.
No, what we are trying to say
You
is
come to your last point.
Last point. That this 105 is not under challenge. So if 105 is not challenged, how can you injunct the communication? How can you stop and how can you on April injunct and suspend the operation of a September order, which is already taken effect in September?
Okay, you come to your last point.
These 3 points I wanted to make, lordships.
Pardon?
These are the 3 points I wanted to make. One is Order 39, Rule 3. Second is acquiescence. And the third is that he has not challenged the parent order, which we communicated. He has only challenged our letter of communicating the official decision. The official decision itself has not been challenged.
Okay.
So in these circumstances, my humble prayer before your lordships is, if I may just place 105 for a moment, lordships, for my satisfaction, if lordship so pleases.
No, is it necessary? I will go through the same.
Very well. So therefore, in these circumstances, lordships, my humble prayer before the court is, lordships may be pleased to issue notice to the other side. In the meantime, stay this order. And after hearing the parties, lordships may set aside this order and send the parties back to the trial court for a bipartite hearing on the injunction petition.
Okay. Okay. I will pass the order after going to the record.
Very well. I'm very grateful, lordships. And lordships, there's just one thing I need to inform.
Yes.
Which, as an officer of the court, I need to inform.
Yes, yes.
The matter is fixed. before the trial court on 9th of August, sorry, 9th of June. Despite that, we have filed this appeal because the point of plea of Order 39, non-compliance of the proviso to Order 39, Rule 3, perhaps will have to be raised at a higher forum, not before the same court.
Okay. Okay.
So
Okay,
therefore,
alright.
therefore, Lordship,
Okay.
very well, Lorships. Well, grateful for a very patient hearing, Lorships.
Okay.
Very, very good.
Yes.
20 order. Order.
I think Mr. Nath was here. Mr. Nath again is in court number 1, I think, no?
Number 1.
Okay. So after some time then,
Yes.
let Mr. Nath come.
Understanding 3.
This appeal is under Order 43 Rule 1R, and the plaintiff before the learned trial court, my lord. I prayed for an injunction in respect of a plot of land, and that was rejected. Against that, I have come. And the plaintiff has 2 adjacent plots. The plaintiff has 2 adjacent plots. One was mortgaged to the bank, and the other was not mortgaged. The bank we have taken a loan and mortgaged the other property. Bank has now put up a sale notice in respect of the other property. Now, since they have put up the notice in such a way as if both the properties are involved, we filed a suit saying that so far as this part is concerned, kindly declare my title. And in the meantime, I have prayed for temporary injunction. I'll show from the documents, my lord, the bank is not disputing the fact that this property, this land is not mortgaged. In spite of that, my injunction was refused. That is why I have come before lordship. My learned friend is appearing for the bank.
Lordship, in this case, there is a series of litigation. The petitioner has earlier filed SA 48 of 2020 before the Tax Recovery Tribunal, which is the competent court to decide the dispute. And earlier petition was a stay order was given subject to deposit of 25% of the demand amount. Thereafter, the petitioner did not appear. That was dismissed. Subsequently, when the bank went to take physical possession, another SARFAESI application was filed, SA 40 of 2021, and that was dismissed on merit. That was dismissed on merit.
Merit.
There you go, Lordship. This petitioner has also filed one writ petition, and that writ petition is pending before the division bench because the subject matter is of SARFAESI. And that case is WPC 2381 of 2026. That case is pending before the Chief Justice, and it is fixed on 19/6 against the. So, since bank has taken steps under the SARFAESI Act, civil court has got no jurisdiction. Accordingly, the petition for injunction was rejected by the learned civil court.
May I now place my land has placed his case. And this is the ground on which my prayer was rejected. But when I say that there are 2 plots, one is mortgaged, other one is not mortgaged, bank doesn't dispute that. The dispute, whatever it is, my lord, some petition filed, dismissed for default, etc., is in respect of the other plot, which was mortgaged. So far as this plot is concerned, nothing is pending. Why you are refusing on injunction? Lordship, may just allow me a couple of minutes, I am showing, my lord. Lordship, may kindly turn to page 13. Very interesting, my lord. Page 13 is the plaint. Now, page 14, para 1, Lordship will kindly see that the plaintiff is a permanent resident of so-and-so. The mother of the plaintiff, so-and-so, during her lifetime purchased land measuring total an area of 8 katha 18 gandas in RS number so-and-so, patta number 27, dag number 132 of so-and-so, by two separate registered sale deed given, my lord. After the death of said mother, the plaintiff and his brother, being her sons and only legal heirs, became the absolute owner of this said land measuring an area of 8 katha 18 gandas of by right of inheritance, and each of two brothers, that is the plaintiff and the said brother, having half share of the above mentioned total land measuring an area of 8 katha 18 gandas, that is an area of 4 kathas and 9 gandas each. Thereafter, brother of the plaintiff Sandeep Patkia, in requirement of money, transferred and conveyed his ownership right, title, interest over his half share of land, that is land measuring an area of 4 katha 9 letter, in favor of the plaintiff by registered deed number so-and-so, dated so-and-so. And in the aforesaid manner, the plaintiff became absolute owner of the entire land of 8 katha 18 gandas of land with specific boundaries. Now, next page, just one more paragraph I am showing, my lord. Para 2, I have mentioned that the plaintiff had applied for loan in Punjab National Bank, and for this he submitted a project report and filed an application at the bank. After due verification, sanctioned cash credit and one vehicle loan amounting to rupees 1.68 crore, I think, my lord, only for his contractual work. In the said loan, he himself stood as a mortgager of the said land measuring an area of 8 katha 18 gandas, together with structures, etc. Now, my lord, next paragraph I have mentioned that because of my lord COVID and one particular work I have done under the irrigation department, payment was not made, I could not pay. Thereafter, the bank proceeded, my lord, page 16, Lord, will kindly see. Thereafter, issuance of possession notice dated so-and-so, the defendant bank issued one sale deed number so-and-so against the plaintiff. Being aggrieved by the said sale notice dated so-and-so, the plaintiff had preferred one surface application before the Honorable Debt Recovery Tribunal, Gauhati, which was numbered as surface application number 48 of 2020. In the said surface application, the defendant bank duly appeared, and after hearing both the parties, Honorable Court by order so-and-so was pleased to grant stay of all the further proceedings in the said surface proceeding. But for non-appearance of the learned counsel for the plaintiff, the said surface application so-and-so was dismissed for default. Now, paragraph 5, I have mentioned that subsequently the defendant bank issued e-auction notice, sale notice, dated 8/7/21 in respect of the mortgage property, that is the land measuring an area of 8 katha 8 gandas, 18 gandas, and the structure standing thereon, which was mortgaged by the plaintiff by depositing his purchase deed number so-and-so as aforesaid. But recently, on 30th of August 2022, the defendant bank affixed a banner with remarks that the property belongs to Punjab National Bank on the outer gate of the state property described in the schedule below, measuring an area of 3 katha 18 gandas covered by RS part number so-and-so, dag number so-and-so, appertaining to Moja, Kanapur, etc., my lord, which was purchased by the plaintiff by a separate sale deed while registered deed number 2286 dated 13/5/2008. This land measuring 3 katha 18 letters covered by a different sale deed is not mortgaged. Now, Lordship will kindly see how they have given reply of this, my lord, at page 36 in the written statement. Page 36, my lord. That as to the statements made in paragraph 5 of the plaint, the answering defendant begs to state that the defendant bank has taken physical possession of the mortgage property on so-and-so in accordance with the provisions of the Surface Act 2002 and the rules framed thereunder. The answering defendant further states that the physical possession of the mortgage property was taken in presence of executive magistrate and land officials. Thereafter, physical possession was taken up by the mortgage property. The defendant bank placed security personnel in the mortgage property, that the plaintiff accompanied by some hooligans trespassed and have forcefully entered into the mortgage property on so-and-so, of which possession was taken by the defendant bank on 30th August 2022. The defendant bank has immediately lodged complaint with Silchar police station on so-and-so containing inter alia the trespass of the plaintiff in the mortgage land. It is denied specifically and categorically that the defendant bank has put banner in the outer gate mentioned in the area as 3 Katha 18 Gandas. They are saying that we have not done it. That the defendant bank has taken physical possession of the mortgage property on being identified by the appropriate land officials of the government. That the defendant bank has taken possession of the mortgage property and not any other property. Let's look kindly see. Not any other property. Be it mentioned herein that the plaintiff has cooked up a story just to create confusion without any element of truth and also to misguide this on court. The answer defendant begs to state that the plaintiff has not annexed the possession notice banner alleged to have been affixed by the defendant bank on the outer gate of the property. The plaintiff has also not mentioned that the date of possession notice alleged to have been affixed on the outer gate of the property. Such non-disclosure of the facts by the plaintiff itself shows that the plaintiff has made vague and cooked up statements only for the purpose of suit without any element of truth. The answering defendant states that the land under sale deed number 2286 is a vacant land, the land which was not mortgaged, my lord. This is covered by deed number 2286. Bank is saying, answering defendant states that the land under sale deed number 2286 is a vacant land as per admission of the plaintiff in the power of attorney dated so and the RCC building is on the mortgage land. So they are not disputing that the other land covered by sale deed number 2286 is not mortgaged and I am the owner. I have given the sale deed number, etc. That they are not disputing, that they are not answering anything. They are simply saying that that is a different one. Now, how the learned trial court has dealt with the matter, and Lord will kindly see. It's a huge order, my lord. It starts from page 50, and I'm just showing the operative part, my lord. All the stories in respect of the mortgage property the court has mentioned, and while rejecting, my lord, page 60, just one page, the ultimate finding, my lord, page 60, my lord. I have already, Lordship's got, my lord. I have, second paragraph, I have already heard the learned counsel appearing for both the sides. I have also gone through the materials on record and considered the rival submissions of both the sides. Perused also the photocopies of the documents submitted by both the sides. It is apart from the perusal of the case record that the plaintiff petitioner has challenged the SURFACE action initiated by the defendant bank before the Debt Recovery Tribunal by its SURFACE application number 40 of 2020. Now, the property which has been alleged to be illegally and arbitrarily affixed with possession notice of OP Bank, against which an order of injunction is prayed for by the petitioner, the said property is currently pending for adjudication before the Debt Recovery Tribunal, Gauhati. This is not pending. They are admitting other land is mortgage. This is not mortgage. How the bank court is dealing with the matter? It is said that said property is currently pending for adjudication before the Debt Recovery Tribunal, Gauhati. In view of the same, it is deemed fit by this court not to interfere with the Debt Recovery Tribunal. I am not challenging any Debt Recovery Tribunal order, my lord. I am only saying that there are two plots. One is covered by this particular sale deed. It is measuring this much. The other one is covered by a different sale deed, and that is covered by different log number. You are not disputing. Bank is not disputing that. Now, bank is taking advantage of that fact that the some SURFACE action is being taken in respect of the other, so I will not grant injunction in respect of this land. It's a clear statement I have made in the play.
No, but that land was attached by the bank.
Mortgage properties, my lord, they have put up a initially
this the other plot of land.
Other plot is not, my lord.
3 Katha 18 Ganda.
Yes, that is not mortgaged.
But they have attached it.
No, they are disputing that we have not put up any sale notice before the gate of this 3 Katha 18 Ganda. I have shown from their written statement. Because they know, my lord, this is not mortgaged. Only thing is both are adjacent land, my lord. And apprehending that what will happen, my lord, in the auction, they will sell as much land as they want, but whereas my other land covered by other dag number, patta number and sale deed measuring 3 Katha 18 Gonda is not mortgaged. You cannot sell that. And the court is saying that some surface action is pending, etc. It's not pending in respect of this land. And I have made specific averment, they have admitted, because they have not denied that the other part of the land is not covered by any mortgage deed.
So in that plot of land also, they have affixed the possession notice.
That they are denying. They are in the written statement, as I have just now read, my lord.
No, the finding of the court.
Yes.
The-
Finding of the court is very simple, my lord. Court has taken shelter under the debt recovery tribunal proceeding. In respect of this land, there is no proceeding.
No, the finding is
My lord.
this.
Yes.
Now the property
Which has been alleged to be illegally and arbitrarily affixed with possession notice of OP Bank, against which an order of injunction is prayed for by the petitioner. The said property is under currently pending for
So
adjudication.
in that part of land also, they have affixed the possession notice.
Yes, we have alleged that. To that extent, my lord, there is a denial. They are saying that we have not put up that notice on that land. Court is saying that property which has been alleged to be illegally and arbitrarily affixed with possession notice of OP Bank, against which an order of injunction is prayed for by the petitioner, this part is okay. Now the court is saying the said property is under currently pending for adjudication before the debt recovery tribunal. Let my learned friend say whether in respect of the other land which is not mortgaged, whether any debt recovery proceeding is pending.
May I please? Your lordship may come page 59. Third paragraph.
No, if the other plot of land, that is a 3 Kotha 18 Ganda is not
Your lordship, I am
mortgaged.
coming to that point.
No, you first answer my question. If it was not mortgaged, how can you affix the possession notice over that plot of
We
land?
have not affixed the possession notice over that plot of land. But here the case is that against the petitioner, one recovery certificate is issued by the debt recovery tribunal.
In respect of which land? That is the question, my lord.
No, it is not that. You are liable for the bank and your entire property because there is a personal decree because there is a personal decree against the petitioner under OA 506 of 2019. And that fact is suppressed by the petitioner before the Honorable Civil Court as well as before the Honorable High Court.
Page number?
OA 506 2019.
You were referring to page number?
I am referring to page number 59, Your Lordship.
59.
Second paragraph. It is also stated that the OP Bank has filed OA number 506 of 2019 before the DRT Gauhati. The Honorable DRT by order dated 25/2/2021 allowed the petition by order dated 25/2/2021. And here the certificate amount is rupees 1,61,45,292.54. And it was the liability of the petitioner in the year 2019. With interest, it will go more than 4 crores. As on today. So recovery officer DRT is proceeding. If they get blanket order, the proceeding before the recovery officer will be stopped.
No, the question is if that plot of land is not mortgaged to the bank, can you proceed against that plot of land also?
Under surface we cannot, but under the recovery certificate we can because there is a personal decree against the petitioner. His individual property can be attached by the recovery
No,
officer.
if the Surface Act does not provide it, under which provision you will proceed against that plot of land?
Yes, under section 25 of the Recovery of Debts and Bankruptcy Act.
Under section
25 of Recovery of Debts and Bankruptcy Act. Section 25B, 25H. Because there is a personal decree against the petitioner. And
Nothing is mentioned in the written statement about this. Now, for the first time in
Why
the
not?
appeal, they are taking this stand.
No, in
The
written
appeal,
statement,
London
they
court
mention.
bill also has not taken into consideration this. In the written statement also, they have not discussed. For the first time today, before your lordship, they are taking this plea. Lordship, may kindly see the written statement is on record.
I'm fighting it out.
You are now trying to justify your action by saying that some other fact, some other law, nothing is mentioned in the written statement.
Let me file reply and the date may be fixed. We will bring all the
Yes.
facts in the report.
Yes.
The short date may be fixed.
Is there any stay petition?
Madam, there is. Madam, we filed a fresh temporary injunction petition as normally it is done. Lordship will pass some protection till then, my lord.
And your lordship, already one petition is pending before the Chief Justice, Honorable Chief Justice Court. Writ petition they have filed. They are filing a series of petitions.
No, it does not mean that we will not pass any order here.
I know, but we have stated your lordship regarding the case.
Not DRT case. You are saying that your other property also will go and sell for recovering that amount. This when stand where you have taken in the written statement, kindly show. For the first time before your lordship, they are taking this plea. Now at least they admit that this is not mortgaged, and the court, learned court below is incorrect in saying that we will be taking advantage of the fact that some recovery proceeding pending. I will not grant any injunction. Now at least they are fair enough to say that yes, I am going there on the basis of some other provision of law and the fact that it is your personal property, but for recovering, I will go and catch hold of that property also. That they cannot do.
Regarding this surfacing action, they had already approved the DRT and that petition was dismissed on merit.
Maybe.
That petition was dismissed on merit.
Appeal may be admitted, man.
Okay, we'll admit the appeal. Till filing of the objection, will grant a status quo order?
It should that may be given. Should that may be
Okay,
given for
okay.
this.
1 week?
1 week.
Next week?
Next week.
For service. 10th.
My lord.
Till then, it's status quo.
My lord.
Yes, next item.
Item 5. You look only against the land within 3 katta.
Pardon?
Land within 3 katta, they are disputing.
Yes, yes.
Otherwise, if there is blanket order.
No. That is especially mentioned.
May it please your lordship, this is a statutory appeal, lordship, against the judgment dated 24/7/24. Lordship, in this case, our ground starts with the fact that the income tax return which was exhibited by the claimants was after the death of the deceased. Those were So 2 points that first of all, income tax return which are filed after the death. That means one thing, that there is no loss of income. And secondly, can it be filed, lordship? The court discussed that at paragraph 15, lordship, that was raised by the, and then other grounds are on that occupation.
Okay, today let us admit the appeal.
Yes, lordship.
Mr. Goswami, you were for respondent number 2 and 3. You for? Respondent.
Chibanisha.
Last time 4 also appeared.
4 and
appeared.
5 also appeared. In the causeless names are shown. Because there was a delay petition, lordship.
Okay.
Delay was condoned, lordship condoned the delay last week.
Heard Ms. Mazumdar, learned counsel for the appellant. Mr. Goswami for the respondent number 2 and 3. Mr. Your name, please? R. Paul. Learned counsel appearing on behalf of Ms. R. Saha. S. Saha. Respondent number 1. Respondent number 1.
I am for 2 and 3. 3 is minor.
This appeal under section 173 of the MB Act is directed against the judgment and award dated 24/7/2024. Passed by the learned member Motor Accident Claim Tribunal number 1, Kamrup and Gauhati, in MSC case number 1060 of 2018. Whereas the memo of appeal and the grounds mentioned therein, and also peruse the impugn judgment and award dated 24/7/2024, passed by the learned member Motor Accident Claim Tribunal number 1, Kamrup M. Gauhati, in MSC case number 1060 of 2018. Admit issue notice to the respondents. Returnable in 4 weeks. However, no formal notice is required to be issued, since all the parties have entered appearance in IA number,
IA number, I don't.
delay condonation petition.
I.
IA number 2195.
2195 of 2025. This shall reflect the name of the council in the
There,
cause.
it is reflected, Lordship.
Today,
all
all the.
list also names are
Okay, okay. Not required. Recessal call for the record from the learned tribunal. List the matter after 4 weeks. This I is for stay.
Yes, Lordship. Lordship, here 50% may not be possible, Lordship. I would submit, Lordship, that 10 lakhs we can deposit right now and they can withdraw that for the time being, Lordship. Because, Lordship,
40 lakhs is the award and interest. 40 lakhs 27,608. Out of this, minor amount has been directed with deposit, fixed deposit, 10 lakhs. 5 lakhs. 5 lakhs in the name of minor. And in the name of respondent number 1, mother, 10 lakhs has been awarded, and other portion for the wife. So in this particular case, I will take at least 2 lakhs. Without interest, 20 lakhs. 50%. Less than 50%, 20 lakhs.
but it won't add up to 20 lakhs ultimately, Lordship. That's why I was submitting. So, Lordship, let it be 15 lakhs then, Lordship. I'm my senior.
And my submission will be 5 lakhs will be getting fixed deposit in a minor after the deposit amount. That is what we did.
So 15 lakhs we can
5 lakhs
deposit.
will be kept in the registry in the name of minor. Because otherwise also, if interest is calculated, it will be more than also.
No, Lordship,
If
this is.
income also considered, if income tax is not considered, no income also considered, then also it will be above 10. And according to Bhaksha, this has a contractor business and he has income tax return from many years. But wrongly, the advocate appearing for the claimant has not produced the income tax return, earlier income tax return. And the income tax return has been submitted because there is statutory provision that if there is a contract business, he has to his income tax return should be submitted by the legal year. That is why wife has filed the income tax return after his death for assessment area before his death.
Lordship, those are
So here the
disputed.
total amount is 40 lakhs 27,608 rupees.
Yes. 15 lakhs we can deposit and they can withdraw.
No, why not 20?
20, Lordship, it won't add up to 20. That's why, Lordship, even if notional income is taken. That is. And since all the parties are here, Lordship, it will be.
Calculation, Lordship, regarding notional income also I have calculated. It is come to 21 lakhs 98,000 and all.
Notional Kimandori, sir. Notional
10,699.
No, the notional 10,000 can. No, notional 10,000. No.
17, notional income is 10,699. I verified the notification. Then also it will come to 1 lakhs 98,814. Without interest. So 20 lakhs may be deposited and 5 lakhs may be kept fixed deposit. It will be secured in the name of minor.
With a bond, Lordship, then. If Lordship is giving 20.
I'm ready to give the bonus.
Okay. Okay, you deposit 50% of the amount.
So number 1, after the deposit.
Part Ms. Majumdar, learned counsel for the applicant, Mr. Thakur. Goswami for the opposite party number 2 and 3. Mr. For the respondent number 1, opposite party number 1. This Interlocutory application is preferred by the applicant for staying operation of the impugned judgment and award dated 24/7/2024, passed by the learned member, Motor Accident Claim Tribunal, number 1, Kamrup M. Gauhati, in MSC case number 1060 of 2018, till disposal of the MSC appeal. Peruse the application and the documents placed on record, and also peruse the impugned judgment and award dated 24/7/2024. It appears that the learned tribunal has awarded a sum of rupees 40,27,608 rupees. And further, it was provided that the said amount will carry interest at the rate of 9% per annum from the date of filing of the claim petition, that is 25/5/2018, till the date of realization. But taking note of the submission of learned counsel for both the parties, it is provided that the impugned judgment and award dated 24/7/2024 stands state till disposal of the appeal, subject however to depositing of the 50% of the awarded amount by the learned tribunal, and out of the said amount, a sum of rupees 5 lakhs shall be kept in fixed deposit by the registry.
Registry in the name of respondent number 1, respondent 2.
By the registry in the name of respondent number
Three.
3, respondent number 3. And remaining 15 lakhs shall be released in favor of the respondent number
Respondent number 1, 10 lakhs in favor of respondent number 2. Because
10 lakhs in respect of respondent number
1, 5 lakhs, and 10 lakhs in favor of respondent number 2.
Respondent number 1, 5 lakhs, and 10 lakhs in respect of respondent number 2.
On proper identification.
After proper identification. In terms of this, I stands dispose of.
Then Lordship, instead of 50%, Lordship may write 20 lakhs because the division is such. 10, 15.
20 lakhs. Okay.
Highly obliged.
Item 6.
Okay, this is an injury case, and total award was 37 lakhs. 23 lakhs. So we'll deposit
This
50%
for enhancement or what?
Lordship.
Well, you are for the insurance company.
Insurance company.
Okay.
We'll deposit 50% Lordship.
The appeal
It may
is
be released
not
also.
yet.
Lordship.
I is there. Third, Mr. Goswami, learned counsel for the appellant. This appeal under section 173 is preferred, of the MP Act is preferred by the appellant. Challenging the judgment and award dated 24/2/2026, passed by the learned member, Motor Accident Claim Tribunal, number 1, Kamrup M. Gauhati, in MSC case number 888 of 2020. Here is the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and award dated 24/2/2026. Admit issue notice to the respondents returnable in 4 weeks. Step be taken by speed course and also by usual process within a week from today. This is a call for the record from the learned tribunal. List the matter after 4 weeks. What was the amount?
23 lakhs and all. We'll deposit 50%.
Okay.
And that may be released also in favor of the claimant. That may be released also in favor of the claimant. On
But a
appearance.
claimant is not present before this court.
Lordship, they will have made application after appearance. I have no objection for release also.
Pardon. subject however to depositing 50% of the awarded amount, and on such amount being deposited before the registry of this court, the claimants will be at liberty to withdraw the same by filing appropriate application before the registry of this court.
Obligations.
May I please, your lordship? In this case, an insurance company has filed this appeal, lordship. On and but the awarded amount is 6,40,000, lordship. Today is the first date for. So lordship, pay the matter, lordship, after depositing 50%, lordship.
Art, Ms. Forman, learned counsel for the appellant. This appeal under Section 173 of the MB Act is directed against the judgment and award dated 27/2/2026 passed by the learned member, Motor Accident Claim Tribunal, Tinsukia, in MSC case number 27 of 2023. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 27/2/2026. Admit, issue notice to the respondents returnable in forex. Step be taken by speed post and also by usual process within a week from today. Registers will call for the record from the learned tribunal. List the matter after forex. I have 50% amount
Yes, lordship.
within a period of
It is a
four
period of
weeks.
6 weeks, lordship.
4 weeks.
4 weeks.
Pardon?
Public.
May I please, your lordship?
Yes.
Lordship, I am appearing for appellant claimant, lordship. We prefer this appeal for enhancement.
Enhancement.
Yes, lordship.
What was the amount granted by the
Amount was
tribunal?
31,777.
Only.
Lordship, claimant had previous injury, lordship. And honorable tribunal not taking the previous injury.
Whether there was any disability?
No, no disability certificate not.
Disability was
But
not there.
doctor has examined. Doctor's examined, lordship.
Heard, Mr.
A.U. Ahmed, lordship.
A.U. Ahmed, learned counsel for the appellant. This appeal under section 173 of the MBA is directed against the judgment and award dated 21st of February 2026 passed by the learned member, Motor Accident Claim Tribunal, Sonitpur, in MSC case number 21 of 2024, which indicate injury filed under section 164 of the Motor Vehicle Act 1988. There is the memo of appeal and the grounds mentioned therein. And also, there is the impugned judgment and award dated 21/2/2026. Admit, issue notice to the respondents returnable in 4 weeks that be taken by speed post and also by usual process within a week from today. This is a call for the record from the learned tribunal. List the matter after 4 weeks.
Obliged.
Okay, this is an appeal filed by the insurance company. In this case, the driver did not have a valid driving license. We proved it, lordship, but pay and recovery order was given to us. Because as per the new act, lordship, there is no provision for the pay and recovery, lordship. That is we filed the appeal, lordship. So appeal may be admitted, lordship.
Heard, Mr. K. Bhatt, learned counsel for the appellant. This appeal under section 173 of the MBA is directed against the judgment and award dated 18/3/2026 passed by the learned member, Motor Accident Claim Tribunal, Gwalpara, in MSC case number 380 of 2020. There is the memo of appeal and the grounds mentioned therein, and also there is the impugned judgment and award dated so and so. Admit, issue notice to the respondents returnable in 4 weeks. Should be taken by speed post and also by usual process within a week from today. List recessal call for the record from the learned tribunal. List the matter after 4 weeks. IA for stay.
Regarding IA, lordship, notice may be issued, lordship. Notice may be issued, lordship.
Heard Mr. Bhatt, learned counsel for the applicant. This application is prepared by the applicant stroke appellant for staying operation of the appeal judgment and award dated so and so. Passed by the learned member Motor Accident Claim Tribunal Goalpara in MSC case number 380 of 2022. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process. We can know it come to the list after 4 weeks. Next.
Item 11 and 54.
Mere case lawsuit. This statutory appeal has been filed by the insurance company only on a single ground lawsuit. The offending vehicle was a HMV transport truck, but the driver who was driving at the time of the accident, he has only an LMV license. So at the time of the accident, he was not authorized to drive a truck lawsuit. We have reduced the DW1 of our investigator and the DW to the RTO people. They have also computed, learned tribunal has not taken into account that and asked to deposit the whole amount first.
License was for LMV
LMV.
and the vehicle
Was a truck. HMV. Truck. It was a HMV transport. Lawsuit may come to page 26.
Let notice go at this is as what. Heard Mr. Sarji, learned counsel for the appellant. This appeal under section 173 of the MPA is prepared by the appellant, the New India Assurance Company Limited, challenging the judgment and award dated 4/2/2026. Passed by the learned member, Motor Accident Claim Tribunal, North Salmara, Vayapuri, Boigaon in MSC case number 164 of 2019. Pairs the memo of appeal and the grounds mentioned therein, and also pairs the deemed judgment and award dated so and so. Admit issue notice to the respondents, returnable in courts that be taken by speed post and also by usual process within which come to be. Shall call for the record from the learned tribunal. This is the matter after 4 weeks. I is for stay.
Lawsuit.
Subject, however, to depositing of 50% of the awarded amount before the registry of this court.
Lawsuit, but that should not be released.
The question of releasing does not arise because the other side is not present before the court.
But see, this is a case of head-on collision between two vehicles, lordship, but entire liability is imposed on the present appellant, lordship. So our context is that we are.
Head-on collision.
Yes, lordship. Our liability is 50%.
Pargana, admit. Or stay 50%.
Item 13.
So in this case, we have challenged the quantum of award, let's see.
Quantum.
Quantum, let's see.
What is the quantum?
Quantum is, let's see. Awarded amount is 5,34,107, let's see. Regarding medical expenditure, let's see, 3,47,107. The claimant had a let's say mediclaim, and that amount was reimbursed. That is why he is not entitled to that amount. Let's see, he exhibited the photocopy of medical voucher of that amount. Let's see, since that amount has already reimbursed by the mediclaim policy, so he will not entitled this amount. Let's see.
Whether you have taken such a stand before the tribunal?
Yes, let's see. We adduce evidence. Let's see.
Your lordship, I'm referring for the claimant, respondent number one.
Respondent number one.
Your lordship, regarding, we will deposit, we will deposit 2 lakhs, lordship.
Or there is that 50% of the amount may be deposited, because this is totally a different case. They are standing in the shoes of the top fees, but and that mediclaim is completely contractual, is a different cost. It has nothing to do right again, even a party. And one is statutory reference and other is contractualized, where we have to make the payments of the premium, that there's a total difference. It let me have a hundred such contract, but that contract has no impact and cannot deprive of his actual statutory claims. I don't know how it's in a very statutory, it can be stated not monthly.
Okay.
But bring around those things.
Heard Mr. KK Bhatt, learned counsel for the appellant, Mr.
Deposit.
Yeah, your name, please.
Arguswamy. Rishi Arguswamy.
Arguswamy.
Yeah, I'm here on behalf of the claimant.
Okay. Respondent number?
Respondent number one. I'm the
One.
claimant, yeah.
Respondent number one. This appeal under section 173 of the LBA is directed against the judgment and award dated 9/3/2026, passed by the learned member, motor accident claim tribunal number 1, Kamrup M. Gauhati, in MSC case number 991 of 2021. Further the memo of appeal and the grounds mentioned there. And also further the impugn judgment and award dated so and so. Admit issue notice to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, since Mr. Goswami entered appearance and received notice. However, extra requisite copy of the memo of appeal be furnished to him during the course of the day. Rest will call for the record from the learned tribunal, list the matter of preference.
Regarding IA, lordship, we will deposit 2 lakhs, lordship.
2 lakh, I have if the one time hearing, it need to be, if I have an objection over here, because I do not know why even if.
Okay, 50% of the awarded amount.
Along with the interest between.
No, lordship, lordship, medical
Lordship,
expense.
it is a very clear here statutory.
No, lordship, I will- I will-
No. Mr. Bhatt, you deposit 50% of the awarded amount.
But they should not be allowed to withdraw that 50%.
Why?
Otherwise, what's
Why?
the use of, what's the purpose of it? What's the purpose? If it is not like a bond that insurance company such will flag away, what's the purpose of depositing? The purpose of the depositing is for
No, you will-
relief of the claimant.
We will not
Heard,
done that for
Mr.
double benefits, lordship.
Okay. Heard Mr. Bhatt, learned counsel for the applicant, Mr. Goswami for the respondent opposite party number 1. This interlocutory application is prepared by the applicant for staying operation of the impugned judgment and award dated 9/3/2026. Passed in MSC case number 991 of 2021, passed by the learned member, motor accident claim tribunal number 1, Kamrup M. Gauhati, in MSC case number 991 of 2021. It appears that the connected appeal has already been admitted for hearing and the record has been called for. And as such, there is a requirement of staying operation of the impugned judgment and award dated so and so. Accordingly, the impugned judgment and award dated so and so stands state till disposal of the MSC appeal, subject however to depositing of the 50% of the awarded amount before the registry of this court within a period of 4 weeks from today. And on such deposit being made by the applicant, the respondent opposite party number 1 will be at liberty to withdraw the same, subject however to
furnishing
furnishing
bond,
one indemnity bond.
By furnishing bond.
Indemnity bond.
Okay.
No, see, this is a case of head of collision, same fact, lordship, item note 12.
Okay. Same order.
I would like to.
May appeal. This is an appeal for enhancement.
Heard Mr. Bhattacharya, learned counsel for the appellant. And Mr. Your name, please. Learned counsel for the respondent number 1. This appeal under section 173 of the MB Act is directed against the judgment and award dated 5/3/2026 passed by the learned member, Motor Accident Claim Tribunal. Number 2, Kamrup M. Gauhati in MSC case number 1215 of 2019. Whereas the memo of appeal and the grounds mentioned therein, and also whereas the MP judgment and award dated so and so. Admit, issue notice to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1. Since Mr. Dotto, learned counsel, entered appearance and received notice, however, extra requisite copy of the petition be furnished to him. Extra requisite copy of the memo of appeal be furnished to him during the course of the day. Step upon rest of the respondent be taken by speed post and also by usual process. We can have it from today. Rest is a call for the record from the learned tribunal. List the matter after 4 weeks.
Like
What is the amount?
amount 9,35,272.
There is no application for stay.
No, this is for enhancement.
Enhancement.
Apply.
28.
Whether the 7 lakhs rupees which is lying with the district commissioner can be released to the petitioner or not. Although I have not put the written instruction, but telephonically with the officer, I have discussed. Spoken a lot. But the lordship, because the order that can be released.
Okay.
If that amount is released.
Now, what about the status of the recovery proceeding?
That recovery proceeding, I am waiting. The written instruction, that written instruction I am waiting. Can you give me some time?
State Bank of India's attachment.
Otherwise, lordship's order did it. March.
State Bank of India. Direction order. No, there was an order 33 passed by this court on 33/2026.
Yes.
If your lordship looks into that order, what it says that yes, Mr. Sen submit that he has instructed to appear in the matter, Wakalatnama, to mitigate is given to the same extent we may adjust it due from respondent number in the meantime, so and so. But the money which was lying with the State Bank of India.
7 lakh something.
Yes. Mr. Nat said option is as to whether amount of 7,11,000 is beyond respondent lying with release could go. But what about State Bank of India? Whether that amount can be released to us, he has to take an instruction. SBI, because the whole case is that my money is wrongly given to a private respondent. That is our case.
No, that's all right. This amount is lying with the deputy commissioner.
Yes, correct. No, that can be directly given to the petitioner.
Petitioner.
Yes.
Yes.
And rest 43,10,145 will be due. Wrongly given to the private respondent.
Yes.
And whether that money, whether they have spent, because directly it has come to State Bank of India.
Mr. Sen, you have filed any affidavit here?
Yes.
You will file.
With this time maybe allowed for. So on inspection, the money has already been disbursed.
This was, but you have received the letter of the ADC not to release the amount, but you have released it.
But in the year 2015, that was the order was passed. Thereafter, the person concerned, he approached time and again the price.
No, maybe while one letter was pending with you not to release the amount, then no, that was a letter from the additional deputy commissioner of Surat.
There is a specific order of the fraud. Your question is correct, but there is a communication from the.
Why you have not acted upon the said communication? Okay. Heard, Mr. D. Das, learned senior counsel, assisted by Mr.
K. Mohammed Khan.
K. Mohammed, learned counsel for the petitioner. Mr. D. Nath, learned senior government advocate for the respondent number 5 and 6. 5 and 6. Mr. Sen for respondent number 8. Respondent number? No. 9. Respondent number 9. And Miss for respondent number 8. And you for? S. Datto for respondent number 4. And you for? A. Borwa. Appearing on behalf of Mr. C. Borwa, learned counsel for the respondent number. Mr. Borwa for respondent number 1, 2, and 3. 1, 2, and 3. Person to order dated 38/3/2026. Mr. Dinath, learned senior government advocate, has obtained instructions from the respondent number 5 and 6 and submits that the amount of rupees 9,11,000, which is lying with the respondent number 5 and 6, may be released in favor of the petitioner, subject, however, to adjustment of the his total entitlement. That was rupees 50 lakhs.
50 lakhs 21,000. 50 lakhs 21,954.
21,900 and
50 lakhs 21,954.
Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that subject, however, to the entitlement of the rupees so and so, the amount, the adjustment of rupees so and so, the amount of rupees 7,11,000 shall be released in favor of the petitioner. In favor of the petitioner within a period of 4 weeks. Within a period of 4 weeks from today. Mr. Sen, learned counsel for the respondent number, submits that he may be granted some time to file affidavit. Affidavit in respect of releasing of the amount credited in the bank account of the respondent number
8.
3, respondent number 3.
Private respondent is the respondent number 8.
Respondent number 8. Respondent number 8. Respondent number 8. Accordingly, Mr. Sen is granted 2 weeks or 3 weeks? 3 weeks time to file his affidavit. The affidavit shall also indicate as to why the amount has been released in favor of the respondent number 8, in spite of the written instruction received from the ADC Jorhat. Do you have the date?
I'll indicate one. Page 190, 159,
24/12, 2015. Further, it is provided that Mr. Dinath shall obtain instruction in respect of the status of the recovery proceeding initiated against the respondent number 8 and file an affidavit to that effect before this court. List the matter after 2 weeks. Should we fix a date?
Further hearing, my lord. Your lordship is further hearing of this.
Further hearing.
Yes, my lord, it is 7,11,809.
Yes, yes.
809.
The instruction I have received the telephonic. Can you indicate telephonic instruction?
Okay. Telephonic instruction.
Okay.
Simply update. Further, can it 22nd July? Simply up. Okay.